All right, commissioners and everyone present, thank you for indulging us with that. At this time, I'll open the floor for a motion to return to open session. Thank you, Mr. Marsh. Do I have a second?
Second.
Mr. Elder, thank you. We'll do this by voice vote. All in favor, please signify by saying aye. Aye. Opposed, like sign. And we're back in open session. Next item on the docket is the application that was tabled at last hearing from Chateau Cerise, so I will entertain a motion to remove this item from the table.
So moved.
Thank you, Ms. Katie, and a second from Mr. Marsh. All right. Once again, voice vote. All in favor, please signify by saying aye. Aye. Opposed, like sign. And Chateau Cerise is removed from the table. Do we need to reread the docket, or?
Probably wouldn't hurt, Mr. Chairman.
All right. Do you have the docket?
This is docket PZ-25-013. An application has been filed by
Mr. Chairman, do we want to swear in staff before we get going?
I'll get there as soon as we read this,
All right,
okay?
Thank you.
An application has been filed by Chateau Cherie for a zoning map amendment located at 2419 South Highway 53 LaGrange. The property is a 20.34 acres and currently zoned C1 Local Business District with a proposed zoning of C4 Highway Service District.
Thank you so much. And let's go ahead and get staff sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
All right. Where are
Mr. Chairman,
we?
let me just make a comment here. Mr. Chairman, as the members of the commission will recall, the applicant had made a presentation. The opposition had an opportunity to get up. We were actually to the point where we were trying to figure out what the binding elements might be with regard to this. I think it might be appropriate if staff could get up and just kind of summarize what happened last time and then tell us about what has transpired. I know there were some negotiations trying to resolve that and where they might be about that.
Good morning, Sandy Rugg-Roden, Planner 1, Oldham County. So just, do you want me to just go like to the notes, Barry, just to kind of summarize where we're at, or?
Yeah, you can just basically give a quick overview of what they're asking for, and then, and you might have some of that in your.
Yeah,
Yeah,
I will go down.
and then talk about what we were trying to work through in the open meeting when the matter got tabled.
Okay, so I'll start here. This is a good summary. In 1969, a zoning map amendment was approved to rezone 1 acre from R2 to C1. In 1979, another 9 acres were rezoned, and then 1984, finally, the whole parcel was rezoned to C-1. I'll let the applicant give a little history of the property when they get up of the business. Now they're looking to have it rezoned, the whole property rezoned from C1 to C4 to accommodate a variety of businesses on the property. Let me see, as you can go down, this started in August 2024. It's been tabled a couple times. They've had several meetings with the neighbors. The legacy uses of the property, according to the applicant, are more appropriate for C-1 or C-4, and then therefore that's why they're hoping to rezone it so that they can advertise to businesses that are more in line with the prior uses of the property. The two biggest issues are traffic on Zale Smith Road and the unknown future use of the property. The applicant has agreed to restrict traffic on Zale Road. Let me go down to this really quick to show. So you see the picture on top is looking towards the property on Zale Smith Road, and the red square is that intersection, and then the red line on the picture all the way to the right is the one that is where they're restricting traffic. And all traffic for Chateau Cerise is off of 53, so that issue's been resolved. The biggest issue here now is the uses of the property. The applicant and the neighbors have met, and they've agreed to some uses being excluded for future use: adult entertainment establishments, manufactured home sales and services, Conditional uses, auto auctions, borrow pits, quarry, gravel pit, or stone mill, extraction and development of natural resources, aviaries and zoos, airports, helicopters, and other airships or flying machines, takeoff or landing facilities, cemeteries, mausoleums, and crematories. But they could not agree on these uses: the permitted uses of hotels and motels, vehicle services and repair stations, vehicle wash and vocational schools, clinics, buildings and related trade shops, conditional uses of hospitals and institutions, private utility buildings and facilities, sewage treatment plants, contractor equipment storage, mini warehouses, and self-storage facilities. So some of the uses they've agreed to, some they haven't, and that's just where we stand today. Here's the surrounding zoning for the property to get an idea of what's around there and what's appropriate use for the property. Just trying to get down here. These are all of the uses for C-4, permitted and conditional. The items with a check mark are the permitted uses in C1, and then I have noted the conditional uses in C1. The green I highlighted are the ones that they've agreed on, and the yellow are the ones that have not been agreed on. So I can leave that up there if that's helpful. Do you have any questions? Is there any?
And Mr. Chairman, I will say at the last meeting, I think I might have misspoken. There was some discussion about how staff would be able to determine if somebody came in and complained that they were violating what they had agreed to by way of binding element. Because I was not considering the fact that there is going to be a certificate of land use restriction filed that would indicate that these are the permitted uses, even though it's C4. So they can't do everything in the C4 if they agree that there's things that they're going to take off the table. And a certificate of land use would get filed in the clerk's office, putting the world on notice that, in fact, you can't have one of the things that they've agreed up here that they're not going to do. So my concern about that is not as grave as it was when we were here last month.
Fair enough. So, point of order. We have made our way through this hearing. We've had testimony and application from applicant, testimony and application by those opposed to the application. We have not entered into questioning by the commission, correct?
I think that is correct. Actually, my thought would be, Mr. Chairman, is to allow the applicant to get up and explain their point of view about this. Let anybody who's here, I know Mr. Allen was here last month, let anybody who's here that has an issue with any of that get up and explain their point of view, maybe 10 minutes on each side just to get all that into the record, if the commission would be willing to do that. And then at that point, close the floor and let you all engage in your questioning.
Thank you, Mr. Baxter. All right, commissioners, if you agree, then we need to get a motion on the floor to do just that. Mr. Elder?
So move.
Okay. We have an adequate motion, Mr. Baxter? Yes. Thank you. We have a motion. Do I have a second? Second. Mr. Finney, thank you. A voice vote again. All in favor, please signify by saying aye. Aye. And opposed, like sign. All right. Applicant and opposition, 10 minutes each. Let's get that set.
Good morning, everybody, commissioners and
Mr. Gregory,
Mr.
would
Chairman.
you like to get your team sworn in?
might as well. I don't
Okay.
think, I'm not sure anyone will talk, but we'll see.
Okay.
And I'm not even sure I'm going to need 10 minutes, and I know that's bad for a lawyer to say, but we'll see.
Even better.
Yeah, well, let's talk about the questions. Yeah, go ahead.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
All right, it's all you.
Okay, thank you very much, and thank you, Sandy, very much for that. Okay, so we did, after the April meeting, meet with the folks who were there at the time who spoke, and I think most of them were back here today, and have also written letters, so you guys have got those and been able to review them. We actually
Get you
met
just
at
a
the
little
property.
bit closer to that mic so everybody can
We're
hear,
still-
okay?
I know, it's kind of tough, and I'm a little taller than the mic. And I also made the computer go off. We're back. So everything that Ms. Rugroden has outlined in green, the agreed to exclusions, is correct. We have actually added a couple that I did not get to communicate to her because they came up yesterday in discussion between myself and my client. And they are, they're uses that we discussed with, actually the attendees at the meeting were Mr. Allen, Mr. Stetson, Mr. Lemon, and Ms. Schutze. And actually, the two things that I think that we discussed yesterday that we agreed to exclude were communicated by Ms. Schutze. And the concerns are, there are clinics that are listed as permitted use. Let me pull out that, because I don't know that, I don't see it on the sheet that Ms. Rugroden has supplied, but I have it here.
Clinics are right here.
In the office, it'll be, I think
Right
it's in,
there.
right. So in C4, yeah, in the office and professional buildings, there's clinics and immediate care facilities. They didn't have particular concerns about immediate care facilities, but there's been discussion about methadone clinics, treatment, like addiction treatment type of clinics, and that's a concern of the neighbors. And while we haven't necessarily defined that completely, we are in agreement to exclude those sorts of clinics from that designation in C4 if our application is granted. In addition to that, under conditional uses, hospitals, and in a kind of likewise, a concern about the type of hospital that might be located on the property at some point. And that concern ran to, I think the expression was like psychiatric hospitals, treatment facilities of that nature as a hospital. And again, while I don't have a definition for that today, it's something that we can work out when it comes to the certificate that Mr. Baxter suggested. So we agreed to 2 additional exclusions, and they're very specific uses. It would not be the whole category. It would just be those specific uses that we can agree to. And then from the standpoint of the things that we could not agree on, most of that just, from our perspective, comes down to not wanting to unduly restrict what use may be applied in the future. And we don't know what restrictions other properties have around us. Haven't done that kind of research, but we think that what we have agreed to is reasonable. And if I were to cherry pick a few things, I think I understand what the neighbors' concerns are. They voice them and they're going to get up and voice them again, I'm sure. But when it comes to, for instance, a vehicle wash, a vocational school, vehicular service and repair stations, understand the concerns about those things. But one of the things, and those are for, the future uses of the property. We could argue all day about whether something like that might actually locate on this property. If you know the contours of it, the ability to put some of these things on the property, one would cause you to have to knock down about 78,000 square feet of buildings, which isn't necessarily a practical thing to do. And then to maybe even change the contour of the land, which would mean changing the existing ponds and lakes that are on it. And I don't want to get into, too much in the weeds on this, but we just, from the standpoint of reasonableness, we felt like that these were not things that we needed to agree to exclude.
Okay. All right, anything else from your team?
Covered the territory that was involved in the motion as far as, discussing those items? And or am I taking questions now from the commission? Or
We'll come back to the questions. So with that, we'll move on to those who may be opposed to this application and any relevant input they might have to share. And for everyone who's wishing to provide testimony here, we'll need to go ahead and get you sworn. If you would, please stand at this time.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Once again, when you approach, the name and address, please. This is going to be Tim.
Name is Nelson Lemon at 2025 Crystal Cove Drive. Mr. Gregory was correct that we did have a meeting. And we did agree to several things. Unfortunately, from my perspective, we didn't agree to near as much as what we disagreed with. And therein lies the problem, is that all of this was detailed in a letter I sent to each of you. I'm hoping it's in your packet. And, but just kind of reiterate, it was a cordial meeting. It was nice. It was, you know. However, there was too many things that we said, that the owner said we could not commit to because he wanted to keep these options open. So therein lies the real crux of the matter. We've talked about that letter. Let me kind of sum it all up. I won't have to read through the letter because each of you have got it. But let me just kind of sum up the points and the environmental kind of things that I'm looking at. The Cherry House Furniture Store was absolutely successful. We heard last time about how it was the business and the things they did there that would kind of point to a C4 operation. It wasn't. It was a C1. And the contention is that just because they did some things that was outside of C1, that we should go ahead and do it again. But if we do that, we need to understand what is wrong with C1. That's kind of where I'm coming from. What is wrong with the C1 right now? It's not inappropriate for anything, you know. We've got Highway 53. It's on that, but the Cherry House business is no longer there. It's gone. There's no way it can be influencing what we decide for the future. Now, yes, Mr. Whitehouse plans on living on the property for a while. Not concerned about that because I think he would absolutely assured us that as long as he's living there, nothing is going to be happening. And that would be detrimental to the property. However, I'm concerned about when he leaves. At some point in time, it'll have to be. So, but Crystal Lake is still around. And the reason I'm bringing that back is that all the water runoff from that location goes right into Crystal Lake. You know, there's 300 homes back there. You know, we shop here, we play here, we pay taxes here. And for myself and my wife, we would not have moved here had it not been for that lake. So that it becomes, it's an important part of LaGrange. The future of that water quality has to be important for all of us. You know, it's what makes Crystal Lake Crystal Lake. It's the water quality itself. So what will this happen if we allow C4 zoning to be in this property? You know, C4 permits all of the kinds of things like we've talked about before, or brought up before, like the car washes that was just mentioned, the service stations and everything else. All of those create runoff. They will create runoff. And we even talked about machine shops before. And this was something that was pointed out, that these things, machine shops, are not permitted, are not listed as permitted businesses. However, You could look at it as saying machine shops is a service, and the highway service district could offer that. So that's the problem, is that we're not specifically targeting the businesses that could cause the runoff and stuff like that. So bottom line is that Crystal Lake must be protected from the pollutants. There's no reason to do something that's going to allow future businesses of that land to contaminate that property. So, and
Your 5 minutes are up.
okay.
You only get part of the 10 minutes. I'm Jim Allen, 1416 Oldham View Drive. I live on Crystal Lake. And I want to reiterate that we appreciated the meeting and the discussions that we've had with the applicant. Had I known more about being able to subdivide some of the problems that we had with C4 into finer layers, it would have probably been worth the discussion. The point, however, is that there are still categories that are difficult for us, as Nelson pointed out. Things like the automobile usage and things like that. You know, we decided not to allow Christian Brothers here as a county in that because of its sensitivity to the lake. And what we don't know is what's going to happen to this property in the future. It's not the White House's business, it's what happens in the future. And perhaps the certificate of land use will get us there. But in the meantime, I want to point out a couple of things. If this is rezoned Z4, other than Cracker Barrel and Speedway and Walgreens, it's the only C4 on the entire length of Highway 53. There aren't any others. And to me, that just kind of creates an interesting opportunity for a developer who wants to make it into C4. And again, the White House has lived there. I don't have any problem with what they're doing today. But in the future, we need to protect ourselves, I think, a little bit about needing to know what the land use is. Because currently in the plan, there is no land use specified. Basically, they want it very broad so that they can lease it to a very broad number of potential clients. I get that. But without knowing what the land use is, it's very hard to sit here and explain whether or not something is going to be a problem or not. Part of the problem is when you look at these things like, well, I think Mr. Gregory pointed out, clinics. No problem with a clinic, but we didn't want a methadone clinic there. One of the people in the neighborhood actually lived next to one of those and had a bad experience. So I just want to say that we don't have a really good idea of what the conditional uses might be in the future. I also wanted to point out that, well, it basically covers it. What I'm suggesting, though, is that I hate to put in a bunch of complaints without making a suggestion. And so in the documentation that I sent to you all, my recommendations was not to approve C4 as it currently stands. I understand next year that C4, that the zoning and planning and zoning and engineering will be rewriting some of these ordinances. And I think that the study groups on those would be very enlightening, and I'd like to even participate so we can get some of this detail we've been talking about, maybe some more clarification about what some of these things are. What is a vehicle wash? What is a vocational school? The devil is in the details. So I was suggesting that perhaps not approve this C4 and continue with your existing business, because I think Mr. Baxter said at the last meeting that their allowed nonconformance does not expire, so they could continue working that way. And then work on this activity next year with planning and zoning and engineering to try and clarify what some of this stuff means so we don't have these big open, definitions of land use that could be pretty much anything. Thank you.
All right. Anyone else? We haven't gotten you sworn yet, so we'll need to go ahead and get you sworn.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
And your name and address for the record, please.
Joe Hurley. I live at 1705 Zale Smith. This has been ongoing for a while. And the White Houses, they've already said they're going to remain at the property. They're wanting to lease the buildings that they own. They're not tearing anything down. They're not rebuilding the neighborhood. We're worried about water runoff. You know, they're not changing the world here. They're just wanting to lease the buildings they own. I don't see a problem here. I mean, I've been out here since '74, and things have changed a lot. And they have been one of the best neighbors around. I mean, the only thing I hear out over there is the church bells on Sunday morning. And I don't understand the problem here. I mean, you turn down Christian Brothers because of water runoff. Their growth is coming. I mean, look around. I just think it ought to be approved.
Thank you. Appreciate your input. All right. Anyone else? All right, at this time, testimony and evidence are now closed, and we move into questions from the commissioners. Commissioners, you're up. Who has questions? Mr. Baxter, do you have something to share?
Well, Mr. Chairman, I guess I do, because Mr. Allen made a comment. He and I have had a couple conversations about this. And staff is aware of this statute as well. There's KRS 100.253 that talks about existing non-conforming use, continuance, change, effective non-conforming use of 10 years duration, and application. And specifically, subsection 3 of the statute says, any use which existed illegally and does not conform to the provisions of the zoning regulations and has been in continuous existence for a period of 10 years and which has not been the subject of any adverse order or other adverse action by an administrative official during said period shall be deemed a non-conforming use. Thereafter, such use shall be governed by the provisions of subsection 2. Subsection 2 talks about the Board of Adjustments, and so to kind of distill that, if there is an existing non-conforming use, so for example, there's, and I'm not sure, warehouse is not allowed in the C1, right? While Sandy's looking at it, I mean, essentially, if there's a use that they have been using the property for that is a C4 use, an I use, it doesn't really matter, but if there's a use that they've been using the property for and they continue that use, even though it would not be allowed in the C1, if we've gone 10 years, which I believe the testimony is we have gone 10 years, then that use is considered to be is an appropriate use of the property because nobody complained about it. There's been no adverse action. And so it sort of fits here in that you have the evolution of the zoning ordinance over the years and something that they were doing at the time that may have been allowable under the zoning ordinance before may have been made non-allowable now. But the point about this is that that use is something that they are allowed to continue regardless of action by this body, but they can't exchange the scope, so the scope cannot be increased. They can't do something in a different area of the property that would be not allowed in the C1. They can't enlarge the area. So if they've got a 5,000 square foot building that they're doing something that is allowable in the C4, even though they have C1 zoning, they can continue that. But if they decide they're going to add 5,000 square feet to that building, they can't do that. That would be something that would be in violation of this regulation, and it's you all just need to be aware of that, is so that the uses that they have, while they might not be permitted uses in the C1, if they've done those for this period of time and they're allowed to continue that, but they can't expand it, they can't move it, they can't change the scope of it, and they certainly couldn't do a different C4 use in that building than the one that they're already doing. So, I'm not giving you a specific example, but I'm sure that there's things up here that they would like to do but they aren't necessarily allowed to do that in the C1 zone, and they would never be allowed to do that because they're changing the use, the non-conforming use that they've already been allowed because of the elapse of time. So that's something that another little caveat here that sort of convolutes this problem a little bit.
So let me say it differently then. C4 uses continue to be permitted as a result of this provision in some of the buildings on this property.
Existing C4
Existing?
uses. Yes.
Okay,
So different C4 uses, they couldn't now put that building to a different C4
a
use
different C4 use
without
than-
having a zone change.
Okay. All right, so can we run back through the buildings that are on site and how they've been used?
So I'm going to pull up the pictures, and then I'm going to let you explain what the different uses were. Does that work? There you go.
Except I got to work technology while I do this. So, Stephen Whitehouse, the applicant in 2419 South Highway 53, LaGrange. So the original building on this property was the barn. Yep, I already. Maybe I need you to help me.
Okay, you tell me what to point to.
Okay.
Let me go back. Okay, how about
So
this
the
building?
The bottom corner here.
Okay,
That is the barn. That was built as a barn originally. It has been used as a barn, a showroom, a warehouse. And you can come up here to the farther corner, the red brick house. That was originally built as a residence. That has been used as showroom and office space. And that is now being converted into a daycare for people that have leased the building. And come over here. This is the main showroom that was built, that has been added on to 5 different times, and that has pretty much always been a showroom and some office. And then you can come down here to the middle. This is the warehouse. That has been built as a warehouse for that purpose. It's stored furniture. There has been assembly done in there, repair work done on furniture, and office also. And then this is not, that is not the picture of the house. The house is actually off to the side, but there's a house that was built there as residential, and that has been used as showroom and as warehouse at some points in time too. So, is that adequate?
I've got 5 properties there. Are there 5 or 5 structures? I've got 7 photos.
Yes.
So in the middle on the left, that picture is kind of a duplication of the top picture, isn't it?
Yes.
Okay,
Okay. And the
That's
2
2
pictures
pictures
in the
of the
middle
warehouse.
are also a duplication, are they
That's
not?
different views of the warehouse. It's a 70,000 square foot.
okay.
Building.
So we should have 5 structures to talk about then. Now I'd like to know the uses and what zoning classification they fit into. Sandy, can you help us with that?
I did not write down what each one was, so I might need to,
Okay, let's start with the old barn,
okay. So
which was
these-
used as showroom and warehouse.
So your question is what?
What use does that, what use does that, would that typically fall into for zoning classification? Yep. Oh, yeah, get closer to the mic, thanks.
Okay. I gotta get to the pages first. Need more room up here. Let me take this. Okay, so the barn was a showroom and a warehouse. So I would say business professional, offices, not including clinics, that's under C1 as a permitted use.
We do not have the term warehouse in our zoning regulations other than mini warehouses like storage facilities. That's the only time warehouse appears as a category in our zoning ordinances.
All right, does a warehouse fit in C4 staff?
So I would do the warehouse and the showroom as retail and personal service establishments, and those go off square footage. So anything less in C1 has to be anything less than 50,000 square feet. I don't know how big that is. And then after that, it goes up from there to C2, C3, and C4. It just increases the square footage. So showroom and warehouse would be retail and personal services establishments with that gross floor area within the commercial use. So I don't know what the square footage is on the barn, if that's the one we're talking about. 7,600? So that would be permitted in the C1.
Yeah.
If I'm going to speak, I should probably,
Yeah, thank you.
I'll help. I'm sorry, yeah, it's 7,600 square feet on the barn.
All right, thank you.
And the showroom is 19,200 square feet.
Next.
Okay, so what structure do you want to go to next?
So which was the third property? There was another showroom, main showroom, the main showroom.
Yeah. That's the one that's 19,200.
That's 19,000. All right, what was the red brick house? That cannot be 19,000.
It will, it's 3,300 and 3,308 is the square footage on that, I believe. Either that or 4238. We've got two residence-style homes on the property. Which one is that? Right here.
So it's the upper right-hand corner on this graphic.
Yeah, that's this is the brick house, it's 33.
Okay, so 3,308.
Thank you. So let's go back to then the main showroom. We said that was 19.2. So Mr. Fisher, the red brick house at 3,300,
What did they do in there?
that was
That was a daycare?
showroom and office space.
Oh, so I mean, that would be business and professional offices is permitted in C1, not including clinics and immediate care, or if it's showroom, it would fall under retail and personal services establishments, again, with less than 50,000 square feet, permitted in the C1.
Right? And the main showroom, 19,200 square feet.
That's same thing, retail and personal services establishments, less than 50,000 square feet.
So it's C1.
If they're less than 50,000 square feet, pretty much most of the things that they did on their property would be permitted in the C1.
All right. The warehouse,
That's 42,300 square feet. Right. Or 500, 42,536. Oh, the total? Okay, so my bad. The total warehouse is 55,000 square feet,
okay?
So,
over an acre.
So we are at
so that would have to go up to C2.
C2. Right, and finally, the house that was used as a showroom and a warehouse, so the other house.
That'd be C3 for that warehouse under 50,000 square feet, or over 50,000 square feet. You'd have to go up to C3.
Fault, those less than and greater than signs always cause me problems.
So the last house, again, we're somewhere in the neighborhood of, what, 3,000 square feet or
It's 4238.
4238? Okay, so that's back to C1, correct? Feedback?
Yes.
Other than a nod, thank you.
We agree. Yeah.
All right, so the point of that, guys, is just to get an illustration of what the approved non-conforming uses appear to be, and to illustrate the nature of a change if you decided to take up that type of action. Mr. Baxter, please.
Well, and Mr. Chairman, I mean, based upon the C1 classification, I think there was only one that was a C3. So, I mean, all of those uses, those existing uses, are permitted uses in the C1 zone, except for the 42,308 square foot warehouse, which would be a C3.
That's a 55,000 square foot warehouse,
It was clarified.
correct?
Yes.
I'm reading Mr. Douglas's handwriting, so.
Okay, he didn't get the clarification. So it's a 55,000 square foot warehouse. Okay,
Still C3?
C3. Okay. All right, so I don't know if that helps clarify what you're looking at or not. Katie, please.
I do have one quick clarification. It was mentioned daycare was becoming one of those. What, is that C1?
Yes.
Okay, just want to make sure.
All right, so that would be consistent with the past use, unless there's something I don't see there, correct?
Mr. Chairman,
Yeah.
I have a question for staff. Since these buildings are all individual buildings and it's on one property, I'm assuming, we don't take the aggregate of the square footage? Like if one business came in and said they were going to lease the total property, does each building now count as individual square footage, or does it count as to that person that comes in and leases as a total square footage of the property?
Mr. Baxter, correct me if I'm wrong. Baseline is going to be that it's C1 in terms of the approved use, and then in addition, you have an approved non-conforming use of up to C3 in the warehouse, for instance. Mr. Baxter?
Well, Mr. Chairman, I think the confusion comes in, and I think Mr. Douglas makes an excellent point.
Yeah.
The problem is under KRS 100.253, it says any use which has existed illegally and does not conform to the provisions of the zoning regulations and has been in continuous existence for a period of 10 years and which is not subjected to any adverse order or adverse action by an administrative official shall be deemed a non-conforming use. But then you have to jump to section 2, which is how you deal with that non-conforming use. And it talks about the enlargement or extension of a non-conforming use beyond the scope of the area of its operation at the time of the regulation, which makes it non-conforming was adopted. And the Board of Adjustments can't permit a change from one non-conforming use to another unless the new non-conforming use is the same or more restrictive classification. So you get into a whole question of extension and enlargement. It seems to me that applies to the existing uses of the existing buildings. But you're the fact finder. So if you want to find that it's an aggregate use and that the C3 aggregate use exists, and you have factual basis to make that finding, that's up to you.
My question will be to the applicant next, attorney.
Yes, sir.
Obviously, we already know one building is being segregated out from the allotment of the total square footage
Yes,
of
sir.
all the buildings. So is that the plan for the applicant, is to lease out each one of those buildings? Or is it to You just don't have a plan yet.
It would be what you could attract.
Correct.
Yes, it could be individual buildings. It could be, as, I don't know if it was you or Mr. Baxter suggested, it could be, or Mr. Chairman, all of them at once, with the exception of the daycare, which is spoken for at the moment. And I understand. It's a good question. It's kind of the chicken and egg thing we've been dealing with, yes.
The eggs ahead.
Yes.
Yeah. All right.
Yes.
Thank you.
And just for clarity, Mr. Baxter and I have kind of had this conversation. You know, this is all good discussion. My concern is the Planning Commission approved our use of the property 3 times. The last 2 were clearly beyond the code requirement for C1. So, you know, we could be happy with this if that's where we ultimately end up, but at the same time, I don't think we had an illegal use, which is kind of what my whole presentation was about back in April. I'm not trying to shoot anything in the foot, but, you know, when we're starting to parse the different uses of the buildings as we are and trying to figure out where everything fits, I'm concerned about that.
Based on what we just heard, it sounds like it's a very fluid concept.
It's almost ingenious, actually.
All right.
Mr. Chairman.
Yeah.
Mr. Gregory, don't sit down.
I'm sorry.
So, to kind of crystallize this then, regardless of all of that, you're taking the position that the prior uses were legal, even though they may not be necessarily in conformance with our ordinance at this point. But regardless of that, you're asking that the commission approve the change in zoning from C1 to C4. So sort of we're talking about a whole lot of nothing from your perspective, because you want the C4 designation on this property with the limitations that you've suggested.
It clarifies the situation for my client, yes, for the applicant, if we do it that way.
Everyone puzzled as I am? Yeah.
Well, Mr. Chairman, and I know it is confusing, and maybe I've confounded this more than necessary, but I mean you've got an application on the table requesting a zone change. I think there's things that they have agreed on, the things they haven't agreed on. You know, this is obviously a discretionary act. And that's really where the debate comes down to is within your all's discretion. Does someone want to make a motion to approve the change from in zoning from C1 to C4, what the reasons are, and if there are binding elements and restrictions in what you want to do in allowing them to do in that C4 zone?
All right. Yeah.
I have one quick question for you.
Yes, ma'am.
So why the request to go to C4 versus C3?
Well, let me see if I can find. It's a really good question.
I know what you're looking
Actually, I'm looking for what's on my thumb drive.
for. Okay.
So I don't know how to get to that from here. Maybe that. Here we go. It'll be, yeah. It'll be on D. There we go.
Can you go?
And this is going to get back to one of the things I covered in the prior meeting. So I created, and I actually have copies of this. It would be easier for you guys to have paper copies, but I did my own little comparison of C3 and C4 uses. And there's a reason for that, because there is a ton of C3 zoning within a few hundred feet of this property, which I'll also show you in a moment. The major difference between C3 and C4 under the permitted uses is this. the retail and personal service establishments with a gross floor area of less than 100,000 square feet. If we had a development that was, strictly retail and personal service establishments and it's less than 100,000, it fits in C3. In C4, you get the retail and personal service establishments. We're less than 100,000 square feet total on the property, so that doesn't bother us. When we get to the conditional uses, and this is the use that, in getting to what, all of this discussion, the carting and express hauling establishments is a conditional use, so you don't get to just have it. We have to meet the conditions that would be necessary for it. The Cherry House utilized that warehouse for this type of activity for decades. They received furniture, they delivered furniture out of it, they warehoused furniture in it. Mr. Whitehouse testified that they would have up to 18 semi-truck deliveries per week to this warehouse and up to 30 delivery transits out of the warehouse to customers. And as far as we can determine, that fits directly in this category. Now, if we have the C4 zoning, it doesn't mean that we automatically get that conditional use. And we would have to have a tenant who might need that, and then it would have to be applied for. So there's hoops to jump through. But this is the reason, after full discussion and several meetings, not just amongst us, but with the planning staff, we chose this particular zoning classification. Now, let's see if I'm going to have to figure it out from here. I can't see it on the... This is the area zoning map. This is the Cherry House property at C1, C3 next to it, C3 right here, there, all the way up Highway 53 to the interstate. This is the C4 that Mr. Allen was discussing. C3 in other areas, and there's certainly other zoning classifications, but our point is the kind of uses, the most extensive use that we put the property to with that warehouse fits in either C3 or C4 with the conditional use at C4. So moving this property to C4 does not substantially alter the character and use of the area that already exists. We don't know, and this is the problem Mr. Douglas has pointed out, we don't have any idea who ultimately is going to utilize the property and for what purpose. But we're looking for the option that gives us the best possible outcome for the family. And at the same time, we understand that it can't, it change the character of the area, but we actually think that it is compatible with the uses in the area.
All right.
Did I answer the question?
And
Okay.
we may have triggered another. So with respect to what the zoning or what the regulations say, there is not a place where we call for warehouses, but we talk about uses. And the use of the old warehouse seems to me to fit more appropriately with the C4 definition. If we look at the use, not just the square footage. What am I missing here? Why wouldn't that classify as a non-conforming use under C4?
About this? Yeah. Go ahead.
Well, yes. I guess I need a question to you. What in your mind do you feel carting and express hauling establishment means?
It's essentially a fulfillment business. I mean, you can pick one. Amazon would be a fulfillment business. They bring stuff in, they warehouse it, they deliver it. That's essentially what it is. I think if we were to Google it, I think that's kind of what would come up. That's probably not the most scientific and legal way to do it, but that's what's in my mind.
Would you consider a restaurant that does deliveries, carting and express hauling establishment also?
It's a good question, but no, I wouldn't
That
necessarily
would be a
think so.
question for staff, wouldn't it?
Yeah, yes, sir.
So there's different meanings when we're sitting on this commission trying to determine what would fit in that category that you're asking for.
Yes, sir.
When C3 would allow a retail establishment, restaurant, and they have carting and hauling out of their establishment for deliveries, for food. And they're probably in a C3 or could be in a C1.
Yeah, or
So I don't know what the definition would be, and I would guess that would be a terminology or a question for staff.
well, and I would, the
But
only
I know
comment
you're going for the larger size.
Well, the fact that it's a conditional use in that that category leads me to believe that it's a heavier use than, what you're describing. So that's one of the reasons it fits. But I absolutely understand the logic there.
All right. Further questions from the commissioners? Mr. Finney?
Just a clarification, if any new business would come on here and they would build a new facility, they would have to meet all the regulations as far as runoff and environmental standards. They would not be grandfathered into anything that was on the property right now, correct?
So that would be subject to any other site plan review that we would do based off of traffic generation, based off if it was an acre disturbance or more.
Just for the information for the people concerned about the runoff to the lake and everything, if it was a 5,000 square foot automotive type facility or automotive parts facility or whatever, like, they would have to meet the same standards all the others would have to meet for cleaning up the water on the property and everything before it was discharged and off the properties, just as any other business would have, so that it would meet the same environmental standards as required by any other business.
Correct. And this is an interesting case because essentially they're asking for a zoning change without any sort of corresponding development plan. You all typically approve or deny a development plan for a specific business or development and then recommend approval or denial to the appropriate legislative body. In this case, there really isn't a development plan because they don't have an end user yet. With that being said, everything that would come in, even if it would be permitted, would be subject to a site plan review by staff. And if it would, go over the trip generation that would require it to go to TRC or possibly even bring it back here for you all to look at, that would be the case. Or if they're going to look at a use that would require a zoning change, that would be something that, maybe they would have to look to in the future. But, I think for their intentions are, open it up so they can try to lease this space to someone and have that flexibility of the C4. And if you can recall, originally they wanted to go IPD on this. So they've gone down to C4 per se. If you look at going up or going down, they started with IPD and because of kind of some input decided to go back to C4. But yeah, so to answer your question, everything that would come through would be subject to staff level review to determine whether or not it would have to go for your approval or just TRC for trips.
Thank you.
All right, commissioners, so our time is out unless you wish to make room for more. Commissioners, if you have further questions, it's time to make a motion to add some additional time to the commission's section. And if not, then we're moving on to rebuttal and final statements. We good? Mr. Baxter, you have something? No. Okay. All right. So with that in mind, Mr. Gregory, rebuttal?
Actually, I think I've given most of the rebuttal. I would remind the commission that we do have 6 acres of, there's 3 different lakes, ponds on the property. Where the water runoff is concerned, it hits those first. The property is situated, at higher elevation than those, and they actually, one of the largest one bisects the R2 property. So there's probably a total of about a little 2+ acres of lake that's on the C1 property that we're looking to rezone, and then the rest, the larger part of it, is on the R2 property behind it, which is also owned by the family, the White House family, which is the owner of the applicant. And so I don't want to beat a dead horse. I think I've covered all the territory. These were things that I was going to show you in rebuttal anyway, as far as, to me, the appropriateness of the zoning that we're seeking. It isn't going to differ materially from what's already existing in the area. All the things that Mr. Finney pointed out, are things that we've talked about. If there's ever any move to do any additional building or change the configuration of the buildings that are on the property today, including the drives, the parking, everything, all of those things would come back to the planning staff and to the engineering staff for review before any changes could be made. Thank you very much.
Thank you, Mr. Gregory. Mr. Lemon, Mr. Allen, either of you?
So if I got this right, it looks as though the hauling what? Carting and could be done under the existing non-compliance. So I question still why bother with the C4, especially if you could take that ability to do that until we actually get some of the planning and zoning stuff fixed, because as you've kind of pointed out, there's a lot of holes in it that need to be addressed. The issue for me personally, and I can relate to things like the Christian Brothers argument, it isn't what they're doing with the property today or tomorrow, the leasing. The thing is that we don't know what the leasing is going to be. And we don't know who's going to own it after they own it. And if you have C4, a lot of assumptions come with it. And with such bad interpretation or translation of what some of these categories mean, it could mean everything. Our opportunity to deal with it is today and now with your recommendation to fiscal court. And the reason for that is because once it gets into fiscal court, it's very difficult. Once it gets passed, it's very difficult for us to enforce anything. For example, the problem that we were experiencing with the Christian Brothers, the pollution issue. Pollution is allowed to some extent, filing all of the business stuff that we talked about, all the engineering reviews. It is allowed, but what the problem is, when it's allowed and it comes into your lake and it concentrates in a small area and kills every fish, that's a problem. With a small organization like Crystal Lake, they don't have the money to fix that. They don't have the money to review it. They don't have the attorneys to help make sure it doesn't happen in the first place. So we're relying on trying to figure out what the future use of that land is today. So without the definitions and things like that should be perhaps a little clearer and more detailed, and without having prepared a list of what do you call land certificate of land use items, my recommendation would be to say, let's not do this today, but let's continue to work under C1 to C3 nonconformity and try and fix the problem as we move on, and maybe revisit this again when you have a better idea who your customer is going to be. Thank you.
Mr. Allen, before you leave, anything to say? Is that your final statement? Anything else to add?
That'd be fine.
Okay. Mr. Lemon, please.
Just a couple of quick things. Mr. Baxter, I thought I heard you say in the continuous use of anything, of the business or a type of business, warehousing or whatever, would allow that to go on forever kind of stuff, right?
As long as it's not expanded.
As long as it's not expanded. Okay, I would argue that this has not been a continuous use. The businesses over there has been closed for over a year. It's not a continuous use. You know, we've stopped it. The other point that I want to make is that offering this as a way to lease a property is going to set up a precedent for anybody else to come in and say, you know, I'd like to do something with my property. I don't know what I'm going to do with it yet, but in the future I might want to do something. So let me make it C4, or hell, let's make it industrial. So those are the concerns that I have about going forward. We need to think about it not as this one particular tenants or several potential tenants, but what's going to happen when the property is ultimately sold. Thank you.
Thank you, Mr. Lemon. And Mr. Gregory, anything to say in final?
Yes, sir. Just very briefly. The point to me of the zoning ordinance is actually to, support compatible development. And having heard everything, certainly understanding the arguments and concerns of our neighbors, I do not, denigrate that at all. Everybody, in my opinion, brings, a valid concern to the table. On the other hand, we have a property here where to attract people to use it, they have to understand what they can do on it. And to us, the best way to do that is, especially when it comes to the use of the one of the two really primary buildings on the property, is to make the zoning classification match the use that it has received in the past. And again, even if we're granted the C4 application, before we could get someone who would utilize it for, the heaviest use Cherry House put it to, we would still be back, in front the Board of Zoning Adjustments on the conditional use. So it's not a slam dunk, but it gets us, an ability to have a discussion and for this family to utilize this property, for similar uses to what they put it to in the past. And I also believe it's appropriate, given the history of the property, and also given the development of the area and the existing uses around it. So, and I thank you very much for all of your attention today.
Thank you, Mr. Gregory. Okay. That closes the public portion of the hearing. Commissioners, moving into decisioning now. So, Mr. Fisher, will you frame this up for us?
All right, before I begin, I just want to make sure you all have seen in your staff packets, there are 2 letters, maybe 3 that are in the staff packet. For some reason, my third one is just loose leaf. So, but there is a letter from Mr. Lemon, as well as one from Mr. Allen, and then there was a letter from Mr. and Mrs. Stetson on Zale Smith Road. All of them had made comments based off of the proposed permitted and conditional uses that are listed in your staff packet. So I just want to make sure that you have seen those. And then in your staff packet on page 3 and 4, there are suggested motions to both recommend or approve this zoning map amendment, which would go to Oldham County Fiscal Court. So this does not have a development plan, so this will just be a recommendation of approval or denial of this zoning change to Oldham County Fiscal Court. You've heard evidence and testimony from both sides today. You've heard Mr. Baxter tell you about Kentucky statute about allowing a use that has gone on for a certain period of time to continue. And as well in your staff package, you've got 6 proposed binding elements on page 4 that include the following. The approval applies only to the plan presented at the May 27, 2025 Oldham County Planning Commission public hearing. There shall be no changes to the plan without review by the Oldham County Planning Commission and Engineer's Office. The plan must comply with all established federal, state, and county ordinances and requirements and comply with all necessary easement restrictions at the time of construction plan approval. Upon determination and prior to occupation, proposed uses of the facility shall be provided to Oldham County Planning and Development and engineering offices for review and determination if those improvements to infrastructure, or if improvements to infrastructure, are required in accordance with current regulations. Number 5 is in conjunction with this approval, the property owner will not allow commercial access to Zale Smith Road through the adjoining R2 property, which is also owned by the applicant. And then number 6 is the C4 Highway Service District property shall be limited to the following permitted and conditional uses. There is a list provided for you in the staff packet, but I did remove clinics and immediate care facilities, as well as hospitals and institutions that were talked about during testimony by the applicant. With that, I think that includes everything I've got.
All right.
Mr. Chairman,
Mr. Baxter, please.
for the purposes of the record, I think that Mr. Gregory needs to agree with the proposed binding elements. He's been made aware of them, but I think they need to get up and on the record indicate that they do agree to those binding elements, including the restrictions of the C4 that we just talked about.
Okay. Thank you very much. So what we agreed to with respect to the removal of the clinics and hospital were specific uses, that they would not be methadone or addiction treatment clinics, which would fall into the office category in the C1 or C4 zoning. And then and the conditional uses, hospitals, would be psychiatric or mental treatment type hospitals. And again, that's not the most artfully worded.
So you won't be asking, you won't come in and apply for conditional use for a psychiatric hospital?
That's correct. That's correct. And then with regard to the, if you would not mind reading the one binding element that dealt with changes, because we did offer an amendment to the binding element that would require us essentially before we would have any use of the property as we understood it, that we would have to bring that use to the planning staff, and then there would be some determination regarding the need for a traffic study or no need for a traffic study. And Jim, I don't want to misstate but this was proposed by Mr. Silliman, and we had, I'll show you the amendment that we had offered at the last meeting. I believe that we have all of the language, everything that is not in bold is Mr. Silliman's language, and then what we were proposing is, however, any proposed use that would increase the size of the buildings and or parking area in existence at the time of the C1 to C4 map amendment, or that would generally exceed the traffic flow to and from the property generated by the former Cherry House operation. So the first part of that is fairly easy to understand. If there's going to be any changes, we're going to be, any changes that there would be, we're going to be back in front of the planning staff anyway. And then with regard to, and again, we're considering the use of the warehouse and the type of traffic that generated before on the property. The White House family who have operated the property are in the best position at the moment to judge what that was. And what we don't want to do is be in a position where, when there's no process established for us to go to the planning staff and have any particular set of a checklist that we would go through, or timing that we might be able to count on as far as being able to utilize the property. So we had just proposed this amendment to that binding element. Thank you.
The issue with that is there's not a historical, you haven't presented evidence of what you're talking about, what the existing traffic was.
We actually did. I mean, if you accept the testimony that Steve Whitehouse offered at the last hearing, it was up, the peak use of the property was up to 1,000 cars per day on weekends. And then with regard to the warehouse, the semi-truck 18 semi-truck deliveries to and from the property each week, and up to 30 delivery transits. So we have, a fair amount of car traffic established there. But whether that's sufficient.
I'm staring at Hole in the county engineer, and he won't look at me. So
Yeah.
I think he probably needs to comment about this.
Yeah.
Well, I think everyone understands that our intent is to, like you say, understand what the current flow is. And typically we can base that on if we have the traffic counts, and maybe the need is to get those now to have them for comparison. Or because we can use a service called potentially Streetlight that KIPTA offers that can provide historic counts. We utilized it during the pandemic when traffic was not common. So yes, our intent is to have some comparison to the previous uses traffic to be able to establish if they have increased it.
Well, if you had that, would this be acceptable?
Yes.
So number 4, is that the one we're talking about?
Yes.
Would be amended to this, what they propose? Are you satisfied with that?
Yeah.
I think it virtually says the same thing.
Yeah. As long as we've got that data, it's.
So with that being substituted for number 4, are you telling the commission that you're otherwise, and these other small changes you had in number 6?
Yeah, as I understand it, are we going to add a reference to that data into the binding element? Is that what Jim is proposing? I mean, if it works, that's great. I just wanted to make sure I understood.
I don't know that we have to add the reference because you're right, it has to exist anyway.
So no, I don't think you need to add it. I just think, and then the other things you said on number 6, that the modifications on number 6 on the chart.
Yes, sir.
But with those modifications, those binding elements are acceptable.
Yes, sir.
To your client.
Yes, sir.
Okay.
Thank you, Mr. Baxter. All right, commissioners, questions? Motions? Floor is open. This is a recommendation to fiscal court that we are now considering. This will go to fiscal court for them to ultimately consider the zoning change that is requested. Ms. Nassers, is that you?
That's me.
Okay.
I would like to make a motion for approval to the Oldham County Fiscal Court for the zoning map on docket PZ-25013 from C1 to C4. Based on testimony and evidence that has been provided to us, the existing zoning classification that has been given to the property and its use that has been allowed for conditional use of carting and hauling complies with the C4 use that is being requested today. So I am making that motion to fiscal court for approval.
Thank you, Ms. Nasser.
This also includes the binding elements,
Previously.
which are 6 binding elements, number 4 and number 6, which have been amended.
Thank you, Ms. Nasser. Mr. Baxter?
Sorry, Mr. Chairman. Ms. Nasser, you indicated, and I just want to be clear that that if they want to use the conditional use for the cartage and hauling in the C4, they would still have to apply for a conditional use permit, and that is your expectation as a part of your motion, correct?
That is my expectation in consideration for this motion, as it states that also in the binding elements.
Then I think you have an adequate motion, Mr. Chairman.
Thank you, Mr. Baxter. All right, commissioners. Motion on the floor. Do I have a second? Ms. Davis, is that you?
A second.
Okay. Do we have discussion? Any discussion? There being none, we will move into a roll call vote. And as a reminder, this is a recommendation to fiscal court.
Commissioner Davis, Commissioner Gwynn? Yes. Commissioner Hampton?
Yes.
Commissioner Finney?
Yes.
Commissioner Elder?
Yes?
Commissioner Douglas?
Yes.
Commissioner Kraus?
Yes.
Commissioner Jones?
Yes.
Commissioner Nasser?
Yes.
And Commissioner Marsh?
Yes.
It's okay. Thank you, Donna. And the motion to approve recommendation, or to recommend rezoning from C1 to C4 has been approved on a vote 10-0. All right. You guys need a quick break? Yes. Yep, okay. We're going to take 5 25-014. Donna, would you be so good as to read the docket for us, please?
PZ-25-014, an application has been filed by Parkside Estates LLC for a preliminary subdivision plan with a side yard setback variances for 199 single-family lots on a property located at 1909 East Jericho Road and 419 Hoffman Lane, LaGrange. The property is 67.76 acres and is zoned R2 Residential District and R2A Residential District.
Thank you. And Ms. Barge, you'll have staff's presentation.
Hi, Anna Barge, Senior Planner. Good morning, Planning Commission. So as Holly just read, this site is on both 1909 East Jericho Road and 419 Hoffman Lane because it is two different parcels. So the property is currently zoned R2A agricultural, or R2A residential, but is currently being used agricultural. And the proposed number of lots is 199 single family across 67.76 acres. So the original pre-application meeting for this specific project was in May of 2024, with their neighborhood meeting also being in May of 2024, and their technical review committee meeting being in June of 2024. They applied for planning commission back in March, but in April asked to be moved back to the May agenda. The adjoining property owner notices were mailed on May 6, 2025, with a public notice appearing in the Oldham Era on May 8th, and then the agenda posted to the website on April 30th. So there's quite a bit of site history at this location. On October 24th, 1984, a zoning map amendment was completed to change the zoning from R2 to R4 for a nursing home facility. And that was recommended to Oldham County Fiscal Court and was approved on November 20th, 1984. And then there was an issue with the Oldham County Board of Adjustments and Appeals that ruled the removal of and sale of topsoil from property in agricultural districts not a permissible use. And then the board's final action was upheld the determination of the Oldham County Planning and Zoning Administrator that the removal and sale of topsoil is an industrial use. So then in July of 2021, the applicant submitted a technical review committee application for rezoning in a preliminary subdivision plan. And in August of 2021, the Planning Commission approved a recommendation for rezoning along with the preliminary subdivision plan. And then in November of 2021, the Oldham County Fiscal Court approved the rezoning of the property from R2 Residential District and R4 Residential District to the R2A Residential District zoning classification. And that is kind of brings us to today as their plan is now. So this is Jericho Road over here with Hoffman coming down on the western side, and with the entrance being off of Jericho Road, and makes kind of a loop, an inner loop and outer loop format. So these are the parcels in question. You can see the smaller one off of Jericho Road, and then the larger one which connects to both Hoffman Lane and Jericho Road. So the zoning, like I said, is R2A, and you can see there's R4 across the road and R2 on either side with one I2 or two I2 zonings and I1 right here, and then the interstate to the south. So the Oldham County future land use map predicts that the use of this tract will be a single-family residential future subdivision. So as far as conformance with the zoning ordinance, the proposed plan appears to be in conformance with all zoning and subdivision regulations other than the side yard setback variance request. Subdivision Regulation 5.12 Part A, which I'll talk about extensively later, allows for variance requests of setback requirements. So none of the parcels are located in the 100-year floodplain. And then I've also included the TRC comments in your packet. So the applicant is proposing a new preliminary subdivision plan following the open space subdivision design comprised of 199 lots on 67.76 acres. Keep in mind this is an open space subdivision. I'll go more into detail about how that functions differently than our standard preliminary subdivision plans. So the property is zoned R2A residential. The lots will be single-family residential and will range in size from 5,500 to 8,794 square feet with 34.25 acres of open space. Typically, R2A zoning requires lots with sanitary sewers to be at least 7,500 square feet. But because this is an open space subdivision, Oldham County Subdivision Regulations Section 5.12 allow individual lot sizes to be smaller due to the open space sections. So the thought behind this is to compensate for those smaller lots with these bigger open space sections that are deeded in perpetuity. So here's the R2A zoning. It requires a minimum side yard setback of 7 feet just for one side, and then 16 feet total for both sides.
Corridor for that, please. Can you please take that conversation to the corridor?
So as you'll note, R2A zoning has two parts of the side yard setback requirements, that single side for 7 feet and 16 feet for total sides. So we're going to be considering a variance for both of those things today. So to continue my notes, Oldham County Subdivision Regulations Section 5.12A states that the minimum of 50% of the total side area shall be preserved in that open space. So the open space on the proposed Parkside Estates is 50.54%. Oldham County Subdivision Regulation 5.12A calculates the gross density maximum calculation for areas with sanitary sewers as maximum development density equals the total acres divided by the minimum lot size times the percentage factor. So the proposed plan has a maximum development density of 236 dwelling units. The proposed number is 199. So I'm going to highlight a few areas of that Section 1.2 open space subdivision regulations. Specifically, an open space subdivision has the same gross density of a conventional subdivision. However, individual lot size and width requirements are less restrictive, and the remaining portions of the subdivision are dedicated or reserved for non-developmental purposes. So for a conventional subdivision, you would not be able to have like a smaller size lot, but specifically than what's required for that zoning, but open space subdivisions specifically allow for that. Individual lots, and this is where it goes into that, individual lot size and width may be smaller than that required by the zoning district in which the open space is located, and then a minimum of 50% of the total site area shall be preserved. And then that second paragraph already went over that calculation, which gave them that 236 dwelling units number that they could build. They're not building that, they're building 199 units. And then building setbacks may be smaller than the required setbacks of zoning district in which open space subdivision is located. So smaller minimum building setbacks shall be requested through the variance procedure, which is what they're doing today for those side setbacks. And then I also included just the other sections of the open space subdivision regulations, which are in your packet. To continue the notes, so Section 5.12A also states that those building setbacks may be smaller than required. That's what I just went over, so I'm not going to repeat that again. And then Oldham County Zoning Ordinance 070-020 requires the minimum side setback be at least 7 feet on the single side with a total of 16 feet, for the total side yard setback. The applicant is requesting a variance of 5 yards for the single side yard setback and 10 feet for the total side yard setback. And then the Oldham County Board of Education is giving them 31 lots per year. There is a maximum of 35, and they allotted them 31 lots per year. So in summary, for the single side yard setback, they're asking for a 2 feet variance the single side yard setback requirement is 7 feet. The requested single side yard setback is 5 feet. So the requested variance is 2 feet. So for the proposed binding elements for this one, the approval applies only to the plan presented at the May 27, 2025 Oldham County Planning Commission public hearing. For the total side yard setback request, the applicant is requesting a side yard setback variance for the total side yard setback. The total side yard setback requirement is 16 feet. They're requesting 10 feet, which gives you a variance of 6 feet. The approval applies only to the plan presented at the May 27th Oldham County Planning Commission public hearing. It has the same binding element as the last one. And finally, for the preliminary subdivision plan for an open space subdivision, the applicant is requesting approval of a preliminary subdivision plan for an open space subdivision for 199 lots across 67.76 acres. So for the proposed binding elements on this one, the approval only applies to the plan presented at the May 27, 2025 Oldham County Planning Commission public hearing. There shall be no subdivision of any lot into greater number of lots without review by the Oldham County Planning Commission. The preliminary plan must comply with all established federal, state, and county ordinances and requirements at the time of construction approval. 31 lots per year are allowed per the Oldham County Board of Education.
All right, thank you, Mr. Barge. Mr. Silliman, do you have anything to add?
Yes, sir. Good morning. So as is typical for a subdivision development, there will be greater than 1 acre land disturbance. There we go. And as such, the applicant will be required to apply for a stormwater quality management and erosion control permit from my office, as well as a KYR 10 permit from the Kentucky Division of Water. There's also, we observed a proposed stormwater detention basin to be utilized with this pond, and this appears to be in a delineated wetland area. So any impact to a jurisdictional water, whether it's this construction in the wetland or other stream impacts, would require permitting with the Kentucky Division of Water and the Army Corps of Engineers also, and that would come through with a construction plan review to my office. I think you're all aware, but for the audience's awareness also, our construction plan review requires compliance with the county ordinance for post-construction runoff, where we look at the look at stormwater runoff and detention to ensure the 50, 10, and 1%, or also known as the 2, 10, and 100-year storms, are accommodated through stormwater detention practices, as well as the water quality measures that are included in our ordinance. We also have an ordinance for construction site runoff, which means that during construction, appropriate measures are in place to contain sediment on site. And as Mr. Douglas has questioned in the past, we try and the engineering department attempts to inspect these sites monthly during construction, and if there are deficiencies noted, we might get there every 2 weeks, but that is monitored during construction. During the construction plan review, we'll also review the roadway geometry for compliance with current standards. And one thing we will, one small item we'll want to check is to ensure that this turnaround at this stub road allows for appropriate vehicles, whether it's garbage trucks or emergency vehicles, to turn appropriately. There was a traffic impact study provided for this project. One notable change to that has been they've accommodated for the change in the speed limit, where Jericho Road at this location has gone from 55 miles an hour to it's currently 35 miles per hour. Ultimately, this entrance is on a state route, so we'll want the input from Kentucky Division or Kentucky Transportation Cabinet for any improvements they might request. I'm aware that Jason Richardson at the cabinet is reviewing it, but I don't know that he has completed that review. So I think similar to previous hearing, that was Pine Grove Subdivision, where that process was not completed either, we would just request that a binding element be added that any requirements or recommendations of the Transportation Cabinet be included in future design. With regard to the traffic study also, or traffic generation, you'll note there's one entrance, and there's been discussion on whether there would be 1 or 2 entrances to this subdivision. There's 199 lots. However, the Oldham County subdivision regulation states that a subdivision generating greater than 2,000 ADT, which is the annual average daily traffic, would require 2 entrances. If you look at, there's a couple ways you can look at this, and I'll get technical for a second. In my technical review committee letter, if you read that, I kind of focused on the peak hour trips, which was 197 peak hour trips, and sometimes we can figure that that's 10% of the daily traffic, which would put you up around 1,970 trips in a day, just close to that 2,000. Another way to look at it would be if utilizing ITE current trip generation calculations, a single family residence generates around 9.43 trips per day, and multiply that by the 199 and you're closer to 1,877. So it kind of drops that window. So I think just for your consideration when we're comparing the trips to that 2,000 and the question of the number of entrances, it could range from 1877 to 1970. That's all.
All right, thank you, Mr. Silliman. Anything else from staff? Okay, commissioners, questions for staff? Mr. Douglas, is that you?
Sir, Mr. Silliman. So let me get this right on as far as the second entrance.
Yes.
You're saying that at this point, we don't need a second entrance? Or you're saying it's based on whatever the result will be from KYTC?
No. Based on our ordinance and those sources that I've identified, whether it's using the design hour volume at 10% or the ITE trip generation, those are both below the 2,000 vehicles per day ADT that would require a second entrance. They're below that.
Okay, because
the conversation we'd want to have with the transportation cabinet is whether they feel a turn lane is required. The study says that there's not one. I don't dispute that, but ultimately that's the transportation cabinet's decision.
Okay, that was going to be my next question. You answered that. So as far as the stormwater runoff and things of that nature, you did explain about the stormwater management plan will be coming in after the approval and their conditions when they come in for approval for that, correct?
That's correct.
Okay. And then the final is that I'm not sure if staff can answer it or not, but I was reviewing the plan and I noticed it said existing fire hydrants on there to be, I think somebody put that on there. Were they included on the plan? Because I saw some in the immediate area and I saw one on one of the streets, but it's hard to see on these plans. So
Are you asking if the fire hydrants are actually there or if they're supposed to be?
Yes, because I mean, it said on one of the questions Mr. Fisher asked was, include the location of existing or proposed fire hydrants to ensure compliance with Oldham County Fire Hydrant Ordinance. Please include this in your legend. I saw where it says existing fire hydrant. Didn't show proposed new fire hydrants.
I'll let the applicant and engineer address that if that's okay with you.
Okay. I just didn't know if you guys discussed it any further.
We did not discuss that any further.
Okay, thanks.
All right, Mr. Douglas, anything additional? Okay, commissioners, anyone else questions? All right, move into presentation from applicant. Mr. Swansburg. Would you like to go ahead and get your team sworn in?
Yes, sir. That while I'm fidgeting with the computer here, that's probably a great idea, sir.
Okay.
Just for the record, Mike Swansburg with the law firm of Swansburg and Smith, 117 West Main Street here in LaGrange, and I do have some folks here today who either may speak to or would be available for questions from the members of the commission that would need to be sworn in, Mr. Chairman. So,
thank you.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Thank you.
And Unfortunately, Mr. Chairman, I don't have the problem of height in terms of talking into the mic, but if you can't hear me, please let me know. Again, Mike Swansburg here on behalf, and I've got the pleasure of representing Parkside Estates LLC, who is here for a proposed subdivision. There are 2 variances that we are all going to be asking for you all to consider as well, and I'm going to talk about those as we go along here. And Ms. Barge actually did talk a little bit about what's already going on and always does a great job with that. So to the extent I'm repeating her, I apologize for that, but we do think a lot of this is important for us to discuss here today. So again, what's the request? Why are we here? And the applicant, of course, comes before you all seeking the approval of a preliminary plan for a major subdivision located along Jericho Road, just outside the limits of the city of LaGrange, to convert the property you see there in red to this, which you've already seen, which is a 199 lot open space subdivision here in Oldham County. And I'm going to demonstrate for you all here in a little bit about that open space concept. It's a little harder to see with the actual plan itself, but I will show you all what that might look like to get an understanding of that open space that we are talking about and why that matters here. So guiding standards, as I always like to start off with the presentation, what's the law here? What are the standards for us to talk about here? Subdivision regulations sections 1.2a through k set forth following guidelines when considering subdivision development within Oldham County. 1, to guide future growth and development patterns in Oldham County in accordance with the comprehensive plan. 2, to protect the character and social and economic stability of Oldham County while encouraging orderly and beneficial development. 3, to protect and conserve the value of land throughout Oldham County and the value of the buildings and improvements upon the land, and to minimize the conflicts among the use of land and buildings. And 4, to preserve the natural beauty and topography of Oldham County and to ensure appropriate development with regard to these natural features. Those are some of the guiding standards that you all will consider as part of this discussion. Let's talk a little bit about those specific areas. First, let's talk about the comprehensive plan. And the proposed comprehensive plan for this particular subdivision we would submit to you comports with the Oldham County Comprehensive Plan, particularly 1, Land Use Objective LU-1-1, which relates to ensuring that future land uses are compatible with surrounding land uses. 2, Land Use Objective LU-1-2, which discusses managing development in areas of environmental concern. And then 3, Land Use Objective LU-2-1, which talks about promoting connectivity between neighborhoods. Those are 3 areas that we believe, amongst many others, but we would highlight at least those 3 areas of the comprehensive plan that we believe this proposal meets as part of your consideration. Let's talk a little bit more about each one of these, though. Connectivity and infill development. So I highlighted this area first. The part in red, of course, is the property, and then area blue is an existing subdivision that's just to the west of that proposed area. The Oldham County Comprehensive Plan encourages infill development, which, quote, utilizes the existing service infrastructure and lessens the economic cost of expanding utility lines and transportation networks, end quote. That's on page 51 of the Oldham County Comprehensive Plan. We would submit to you that the proposed Parkside Estates subdivision meets this requirement, as it will be located adjacent to an existing subdivision along Jericho Road and will tap into existing infrastructure already utilized by adjacent subdivisions. I used this term in another presentation at one point. I think it's appropriate here. It's this idea of leapfrogging. Right? When you're kids, you stand behind, in a line with each other, and somebody hops over the next one, hops over the next one, right? And so you've got gaps in between there. And what the comprehensive plan says is that we want to discourage this idea of leapfrogging and to promote connectivity and the idea that you've got existing infrastructure. Let's continue to use existing infrastructure when you're developing a new property in this county so that we're not creating excess costs for those utility providers, or quite frankly, for the taxpayers who are paying those costs to make those additions. So we would argue that this, again, is an adjacency to existing infrastructure, and we'll be utilizing existing infrastructure. That's one reason why we think that it meets the comprehensive plan. Open space. Let's talk about open space. Ms. Barrs talked a little bit about open space, but I want to go into more depth to understand what we're talking about and, of course, why it relates to those variances that we're going to be asking you all to consider as well. So Subdivision Regulation Section 5.12, and you've already seen it, but I'm going to highlight it again, It identifies open space subdivisions as an alternative to conventional subdivisions. An open space subdivision, quote, have the same gross density of a conventional subdivision. However, individual lot size and width requirements are less restrictive, and the remaining portions of the subdivision are dedicated or reserved for non-developmental purposes. The purpose of an open space subdivision is to ensure that you're just not blanketing a piece of property with nothing but development, nothing but driveways, nothing but roads, nothing but houses, and essentially not leaving any green space left over within that particular development. The idea behind an open space is that you encourage that additional green space. It has to be at least 50% of the space, and ours has to be at least 50%, which is green space, common green space area that's not covered by a roadway or a lot or a house or a driveway or a sidewalk of some kind. That's the benefit of an open space. But in order to get to that, some of your restrictions are lessened a little bit and make sure that we're trying to encourage part of this concept for an open plan. So I want to put this slide on here because I think it highlights for everybody what this looks like in terms of the open space concept, right? So the black and white version you see just has a lot of lines on it. This one really illustrates, I think, the point of what we're trying to accomplish here. And I've highlighted for those areas in green, which are going to be those open space areas that are going to be part of this proposed subdivision. So again, the proposed subdivision combines 199 proposed lots with 1,491,803 square feet, or 50.54% of the total 67.76 acre lot, if you prefer acres versus square feet, of the undeveloped open space. So again, we meet the threshold of 50% of open space while promoting the retention of green space to preserve the agricultural nature of much of the surrounding area. And additionally, just for discussion here, there was some discussion about its impact on the neighborhood to the west here. The proposal actually will maintain a natural buffer between the development and the existing subdivision to the west. That's part of the plan. So again, highlighting these areas, we've got green space on this side, which there's actually a stream that flows through here, minimizing disruption to the stream. We've got green space here, also again, minimizing disruption to the stream. There is common green space here in the middle, common green spaces down here. Some of these other areas were not as highlighted for being smaller. But again, the idea being that you've got these clustered units together and you've got green space that is around them and in between them so that you promote not just, again, a mass paving of a particular lot with new subdivision. Okay, so what does the proposed open space concept for Parkside accomplish? One, it preserves the natural features of the current lot. That's what I talked about in terms of it's an agricultural lot now. We tried to minimize the actual impact to it and leave at least half the lot still undeveloped, still green space, as we talked about. And also that means it preserves the natural beauty and topography of the area and ensures that development accounts for the natural features of the land. So again, this is, I should just highlight for you where we're talking about here in particular. These areas. So this is the benefit of having an open space subdivision like the proposal we are talking about here today. So what about building setbacks? This is going to get to our variances that we are proposing. So the proposed Parkside subdivision sits within a parcel of land, all of which is zoned R2A. So what is R2A? R2A is I actually pulled the page there so you all can see it beside from the comprehensive zoning ordinance. And pursuant to that ordinance, the minimum lot width for an R2A zone is 50 feet. The minimum front yard setback is 30 feet. So again, minimum lot width 50 feet, minimum side yard setback 30 feet, and the minimum, front yard setback is 30 feet. And the minimum side yard setback is 7 feet or 16 feet for both sides of an adjoining residential lot. Ms. Barge already highlighted this for you here, but I'm showing you where it is on the full page here. That said, individual lot size and width may be smaller than that required by the zoning district in which the open space subdivision is located. And that's found in Oldham County Subdivision Regulation Section 5.12 Sub A. Ms. Barge talked about that a few minutes ago. And quote, building setbacks may be smaller than the required building setbacks of the zoning district in which the open space subdivision is located. That's also found in Oldham County Subdivision Regulations, Section 5.12 Sub A. So again, this is the standard for R2A. However, the subdivision regulations say that if you've got an open space concept, for example, individual lot sizes may be smaller than what is written on this page for the purpose of accomplishing that open space concept. So here are the variance requests. Again, we've talked about them before. I just want to highlight them for you on a map just for visual sake. Consistent again with Section 5.12 Sub A of the subdivision regulations, Parkside is asking the Planning Commission to grant 2 waivers as part of the Parkside Estates subdivision. 1, to reduce the minimum side yard setback from 7 feet to 5 feet or a variance of 2 feet. And 2, to reduce the minimum side yard total setback from 16 feet to 10 feet. That's a variance of 6 feet total. And I just put on here as a note for everyone in case anyone's asking, the subdivision regulation requires a variance request only for change in the building setback. It does not require a variance to reduce the minimum lot width for an open space subdivision proposal. So you may be seeing, for example, here 46, 48, 47, all of which is less than that 50-foot requirement that we talked about. The ordinance does not require you to get a variance for the minimum lot width. It does require you to get a variance for the setbacks, which is why we're asking for those and not a variance request for the minimum lot width. So in support of the request, this is the information, the substance, the meat behind why we're asking this. So we'd say, again, strict application of the R2A spatial requirements would deprive Parkside of the reasonable use of the land. It would not be allowed to do what it is hoping to do if it cannot get these particular variances, especially when we are talking about trying to do open space. And really, we've got a fairly small amount of threshold for us to work with in terms of trying to get the number of lots in and also make sure we have enough open space to meet the requirements of an open space subdivision. So it would deprive them of the reasonable use of the land, the unique conditions of the area, the natural circumstances driving the proposal are outside of Parkside's control. Can't control what the ground looks like or how it's elevated or what it otherwise does. That's outside of Parkside's control. And 3, the proposed spatial alterations resulting from these variances would not harm the public safety or welfare, we would argue. In fact, we'd say, again, the goal here is to reduce the per lot footprint of the subdivision and preserve, to the extent possible, significant undeveloped space. That's the ultimate goal here as part of this request, is that we're trying, again, to preserve as much open space as possible and reduce that per lot footprint that we're proposing to develop. I want to talk about some other concerns that were raised, particularly at the neighborhood meeting, and I think at TRC, that just for everyone's benefit, for the record, at the May 21, 2024 neighborhood meeting, there was a concern raised about whether a new sewer pump would be incorporated into the development plan. I've got it highlighted here. It's in the southwest corner of the plans that you all have there in front of you. It does include a proposed sewer pump station located on the southwest corner of the property, and that will tap into, again, the existing infrastructure. Mr. Silman talked a little bit about transportation, and I do want to bring that up because it was an issue that came up in the neighborhood meeting. It also came up at TRC. So there were some questions or concerns about the impact of the proposed subdivision on traffic along Jericho Road. I actually went out and took a photo. This is the area we're talking about here on Jericho Road, and I wanted to highlight this because, for everyone's benefit, on March 26, 2025, the Transportation Cabinet announced that the speed limit along Jericho Road leading into LaGrange, which does include the proposed entrance to this proposed subdivision, was reduced to 35 miles an hour, meaning that the proposed subdivision will have less of an impact on traffic in the area than previously thought or was previously raised as a concern at one time. That does have an impact on the traffic and in terms of what Transportation Cabinet may require, et cetera. So I do want to highlight that. Second part in terms of this, Ms. Zimmerman is here to answer any questions, but I pulled from her traffic impact study, which we did provide to the staff, is that as part of its application, again, we included the traffic impact study, which analyzed traffic patterns along Jericho Road and taking into account the number of trips and the speed limit in that area of Oldham County, as we just talked about. And the conclusion of the study was that the proposed subdivision does not warrant turn lanes for vehicles coming from the west or the east of the proposed subdivision. So again, that's what was in the traffic impact study, is that at the end of the day, the traffic lanes were not warranted. Mr. Silliman indicated, of course, that the Transportation Cabinet will have the opportunity to make comments and to give input. Ultimately, I did talk to the applicant in this case. Ultimately, we don't really have much of a say in what the Transportation Cabinet does on this front, and certainly would incorporate that recommendation from the Transportation Cabinet into the development. Okay, so I wanted to bring this up real quick to show everybody, and there was a discussion about two entrances and what this subdivision might look like. This is what I would submit to you as a conventional plan. This conventional plan at one point was actually, and I don't have it off the top of my head in terms of dates, this plan was actually at one point, to the best of my knowledge, approved by this body. So we've got a conventional plan where, as you can see here, there are no green spaces. Every part of this except right here to the west was essentially developed, even along up to this road here. There's a creek that kind of flows through here. There were two entrances. There was no green space on this side, no green space along up here, for example. These were all lots in a conventional development. This was the plan at one time. This was the plan at one time. That plan, as I indicated, has changed. This is the proposed plan today. This is the one we are asking you to approve. Again, 199 lots, which, as I wanted to highlight again for you, includes all of the green space and open space that we talked about before. Yes, there are smaller lots, but those smaller lots also contemplate the existence of green space around to, again, utilize and promote that existing terrain that is here in this part of Oldham County. So I want to make sure, again, I'll just a comparison. And for everyone's benefit too, one entranceway versus two reduces, from our perspective, the impact on this stream bed that is here, so that we only have one crossing and one disturbance as opposed to a second one that would inevitably have some disturbance to that stream there as well. So let me give you a little summary of the request from my perspective. So in sum, Parkside respectfully asks, the Planning Commission to approve the following variances. 1, a variance to reduce the minimum side yard setback from 7 feet to 5 feet, or a reduction of 2 feet. And 2, a variance to reduce the minimum side yard total setback from 16 feet to 10 feet, or a reduction of 6 feet. And I highlight for you again the sections of both the comprehensive zoning ordinance and the subdivision regulations that provide for this particular type of request. And additionally, Parkside respectfully asks this body to give final approval of its preliminary plan to construct the Parkside Estate subdivision on the basis that the plan comports with both the Oldham County Comprehensive Plan and the subdivision regulations by, among other things, 1, adhering to the admonition to A, ensure complementary and compatible growth with other areas, such as the neighboring subdivisions that I've already highlighted for you. And B, limit the impact on the environment, in this case, through the creation of an open space concept. 2, to protect the character and social and economic stability of Oldham County and promote orderly and beneficial development. We believe that this plan comports with the normal processes that are required for subdivisions, and we've done, and the applicant has done a lot of work to make sure that it meets the requirements for not just a subdivision, but again, an open space subdivision. And 3, protecting and conserving the value of land throughout Oldham County and the value of the buildings and improvements upon the land, and minimizing the conflicts among the uses of land and buildings. So again, we're talking about a subdivision that's adjacent to another subdivision as well in this part of Oldham County. And 4, utilizing public facilities which are available and which will have sufficient capacity to serve the proposed Parkside Estates subdivision upon its completion. Again, we're talking about tapping into existing utilities and infrastructure and minimizing the disruption and the cost for that disruption. Mr. Chairman, that's all I have. The applicant also, I think, wants to get up and give a couple of words in support of this as well. I'm happy to answer any questions that you or the commission members may have as to me directly, but at this point, I'll turn it over and let the applicant talk a little bit more about that. Thank you, sir.
Thank you. Mr. Jones, let's get your name and address for the record before you get underway, please.
Clay Jones, 7506 Jones Trace in Crestwood. And
need the overhead?
Yes, please.
Coming.
There we go. So I just wanted to emphasize one point in relation to the open space. This is the plan that was approved by Jago Homes in 2021. One lot difference in the entire development, 67 and odd change acres. The open space for this plan, which is very typical for most developments, was a little over 9 acres, that western portion. And then, as we've all seen already, the current plan, which takes that same 67 acres and makes it 34 acres of open space, which I think is just one of the critical elements of what's great about this plan. It's good, I think, for everybody. It's good for the city of LaGrange, which this is right on the border of, and may eventually be incorporated into the city. Just driving by on Jericho Road, you're going to primarily just see open space, trees, and green grass, where you were going to see houses right up along the road. And certainly for the residents of the development, looking out their windows, seeing open space in from almost every lot, and the residents of the adjacent subdivisions, certainly nobody wants to see development right next door, but this is about as low impact as you can get with the amount of open space that's being added. And that's all I had.
Thank you, Mr. Jones.
Thank you.
Anyone else present wishing to speak in favor of this application? Seeing none, moving on to, does anyone wish to speak in opposition to this application? Anyone wishing to speak in opposition to this application? Everyone who wishes to speak in opposition, I'd ask you at this moment to rise, raise your right hand so we can get you sworn in. Everyone wishing to speak, please stand. Please stand and raise your right hand. We'll get you sworn in.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And as you approach the podium, we'll gather your name and address for the record.
Kathy Lewis, 2050 Jericho Road, LaGrange, Kentucky, 40031.
Thank you. Okay, you may go.
Yes. First of all, I want to let you know that I've been living on Jericho Road all my life. And my question is, one, they want to bring the drainage, from my understanding, and from the letter that I read from my father, through our property for the runoff. And we have cows, we have other things that we do with the property. And I'm just curious, can they look at going another route with that? Because they can still have the drainage running off towards the 71, where the expressway is, where it wouldn't affect going through our property and probably later on destroying our land and then the cattle. So I was just curious, maybe I don't know the new plan that he's talking about. However, the old plan did have it coming through my dad's and my aunt's property. The other thing is, which I was listening when y'all was talking about the Cherry House and y'all was talking about transportation and all this. Well, adding 199 plots and most household has 2 cars. I'm just thinking, is Jericho Road, how is it going to affect that? So that's the only thing I'd like to say. Thanks.
Thank you. Who would like to speak next?
Damon Thomas, 201 Washington Circle, LaGrange, Kentucky. Same thing here. The problem that I saw, I know he was talking about the pump on the southwest portion of the property. Well, the thing is with the property that my cousin was just talking about, it's on the east side. And there's no thing. And if you look at when you look at that from the Jericho Road, the property, it sits up almost like on a hill, and everything drains off that hill. And what's going to happen is there's only a couple places it can go. It can either go, like they said, to the 71 or towards our property over there, because they're going to have that pump over there. Plus it's swampland anyway, to be quite honest. But that's what we're concerned about, is the fact that it's steep on that side and it already kind of gets a little swampy, but we still have, cows and stuff like that, agriculture, and they haven't really addressed that side of it. And then on the side note, because like I said, I've lived there basically all my life too, there's a couple things. If they think that them people are going down Jericho Road at 35 miles an hour, they got another thing coming. I'm just telling you, straight up. Them people come around that corner and they're flying. One of the things that I was thinking is, and another thing was, where they had already built a sidewalk coming down Jericho Road. I think the one picture he had was where he was taking the picture from is literally right before an entrance on that right side where there's an apartment complex. There's tons of people that walk up and down Jericho Road, and it's 55 mile an hour. So they should, on that side where the subdivision is going to be, they should extend that sidewalk. I don't know how that cuts into his 50% of the green space thing, but they're going to have it, because what happens is when people are walking from out there, especially those apartment buildings, it's just drainage ditch. It's just a drop off. There's nothing after the road. So what's going to happen is you got people walking down that road, and when cars come, they have to get off the road. Well, I've seen people walking down that road at night, and it's not good. And then the one other thing is when I was looking what they were talking about, they're going to have to put a turning lane coming from LaGrange. I'm just telling you. If not one, if not both sides, because the problem that they're talking about. So when he took that picture and it was looking towards LaGrange on Jericho Road. Well, right behind where he took that picture, it's a curve. And like I said, they come around that curve 55. So if somebody's sitting there and they're trying to make a turn, they're going to have a hard time stopping. So that both ways, they're probably going to need a turn signal. And the other thing is he's doing the one entrance. What if there's an accident right there where somebody's trying to turn and there's no turn signal, they wreck? Guess what? Nobody's getting out of that subdivision for a while. Because as y'all well know, in Oldham County, they shut down the roads when there's an accident. So if there's an accident there, everybody's stuck. They're either stuck in that subdivision or they're stuck, or then they can't get down Jericho Road at all. Because that's it. That's the only way to go. Because they're not going to be able to get through Hoffman. Remember, they're not going through Hoffman, that subdivision, because they're putting more houses there than is in Hoffman. So I'm just saying, I just know whenever there's an accident, they shut down everything, and you're not going to be able to get in and out that subdivision for however long. So I don't know. But our main thing is just the drainage, because on that right side, the south, east side, that's where our land is. So that's the only thing we worry about. They're going to build what they're going to build. That's what we worry about. So thank you.
Thank you, Mr. Thomas. Mr. Swansburg. Can I get some kind of an answer regarding the concerns that were just expressed?
Sure. Let me see if I've got it on mine.
No, go ahead. Doesn't matter, just let it go. Yeah. Would you rather I waited till rebuttal for this?
The appropriate time would be during rebuttal.
Thank you, Mr. Swansburg. Okay. All right. So at this time, is there anyone else wishing to speak? My apologies, I did not see you. Did we get you sworn?
I did, yes, sir.
Okay.
Thank you. Thank you guys for being here. Lindsay Titchener, P.O. Box 373, LaGrange. I didn't have any intention of speaking on this. I didn't know anything about this proposed subdivision. But as it was being presented, a lot of questions came to mind, and I started doing a little bit of digging. One of the things we're very subdivision approval happy in Oldham County. And I don't think we're looking at this particular proposal and taking into consideration some things we need to. Right now, Oldham County High School is over capacity. East Oldham Middle School is over capacity. LaGrange Elementary is very close to being over capacity. This subdivision off Jericho will all flow into Oldham, LaGrange, Oldham County Middle School, maybe East, I don't know. We need to take that into consideration. North Oldham is way under capacity. Why would this not be proposed in North Oldham? Probably because the opposition would be too great for a subdivision like this. We're cramming in 199 homes with one entrance. That brings us to another thing to consider. Fire hazard. Not to mention, we're asking for a variance to shrink the distance between the homes. If one catches on fire, the next one might, and the next one might, and the next one might. And you have one way in and one way out to this subdivision. That's a big concern. And I was watching online before I got here. I know you all went into executive session regarding another subdivision that wasn't approved, and that was because of water and fire hydrants were not approved in the county. And so why would we approve something like this and we won't approve one that's further out in the county? Also was looking at the process to apply for a major subdivision in Oldham County, and I didn't know possibly has a neighborhood meeting happened yet with the developers and the neighborhood members. I think that's step 3 on the application process that's on your all's website. So I just would really encourage you all to take into consideration the growth of Oldham County, the growth of this area in particular in Oldham County and LaGrange, traffic, the concerns for Jericho Road, and the development that's going on out there already with some new apartments. It's something to take into consideration. We are packed in Oldham County. Jericho Road comes right into Main Street, right into that 4-way stop. And I don't know if you all travel that much coming through here, but it is packed and it's crowded. So I would appreciate if y'all would take that into consideration. Thank you.
Thank you. Anyone else wishing to speak? All right. At this time, then we'll move into questions from the commission. Can we reset that now to 30 minutes? Commissioners, who has questions? Mr. Marsh, please.
Mr. Swansburg, sir. In your presentation, I believe I heard you say that we're not asking for variance for the lot sizes, just for the setbacks.
The lot width, yes, sir.
Okay, so not the lot width, just the setback, or the side setbacks there. And then in the Board of Adjustments, your application here, it says that if the variance were declined, the applicant would not be permitted to maximize the use of the property, resorting in either fewer, more expensive lots. It sounds like if you're not asking for a size variance of the lots, you're just talking about the size and location of the structures on the lots. This isn't congruent in my mind.
So what I heard, make sure I understand too, is so there's a couple of things. One was at one point there was some discussion about whether or not we would need to seek a waiver or a variance for the lot width.
Correct.
And there was discussion with staff ultimately that is not a requirement under the ordinance. So that conversation, if I'm going to be honest with you, occurred around the time we were applying and shortly after that as well. And the discussion was that we didn't have to make that. So there may have been some discussion in the application that talks about lot sizes, but in and of itself, the lot size is not ultimately something we need this body to address in any way. So I apologize if there's some confusion, but we are not asking for anything related to the lot size itself because the ordinance doesn't require that. It does, however, require a variance for the setbacks, which is what we are asking for ultimately.
Okay, so the size of the buildings that you're putting on there is driving the request?
No,
or the location?
Ultimately the open space is really driving the request to make sure that we get at least 50% of the property open space. And so we've got a number of lots that we are looking to put in there and maximize the developed space as much as possible. And the house size will have to account for, obviously, the setbacks. You can't build a house
correct
in excess of what the setback requirement is. So the houses will have to conform to the setback requirement. So again, it's the idea of maximizing the space with an open space concept in mind. So again, at least 50% has to be open space. So less than 50%, how do we maximize that space? And that's what we're talking about ultimately looking to do here is maximize that space. Again, in terms of net lot compared to what it was at one time, in terms of approval, there's only one lot difference between this proposal and the one that's before. The lots are smaller than the one that was approved before. But again, the reason for that is because now we've got more open space. So again, a lot of this is being driven by the idea of having that open space to minimize overall the footprint on the property.
Understood. If the variance was not approved, you wouldn't have to reduce the number of lots, though, correct? Because they're all conforming as presented.
If we were to,
Anna,
if the variance was not approved, the question really more for the developer would be, could you practically put a home on that with those variant in the size of the lot in the absence of that?
That's not changing, right?
Assuming that there's just a plan and no variances, the question would be whether you can practically put a home on the usable space within each individual lot.
Correct.
So I don't know as a practical matter if you could. You gotta say that officially.
It is much more difficult. You reduce the house width. The plan with this, the home plans that would be built here with the variance would be 35 to 40 foot wide. And I'd have to do the math without the variance, but it makes it much more difficult.
Okay. All right. Thank you.
Mr. Marsh, anything additional? Who else? Ms. Nasser.
So a few questions. Mr. Thomas brought up one of the questions that I also noted in looking at those pictures. In the speed limit picture, it does show what appeared to be a sidewalk of the neighboring subdivision.
Mm-hmm.
And my question is there intent, I don't see it in the plan, to do a sidewalk that would connect and have that connectivity between the two neighborhoods?
Yes is the short answer. And it's kind of hard to tell on the plan, but yes, it's actually on the plan.
Okay.
So there actually is a sidewalk on Jericho Road that is built onto the plan as well. Now, my understanding is that so there's a sidewalk that goes to the road there, and then you're going to have our sidewalk, and they may not end up connecting to each other because I think there's a property in between that does not have a sidewalk, but our proposed property will have a sidewalk on Jericho Road for the length of the property.
Okay. And then, Mr. Jones, you kind of started to talk about it a little bit, but what style of home are we talking about? Do we have a plan in mind?
I've got Jay's pictures if you want to show them.
We definitely don't have anything definitive, but Mike does have some pictures, I think, on his laptop of some prototype.
Let's go to overhead, please.
Very small houses.
And they'd fit on a lot. Okay, this is not the best way to do this. To be sure. That's even worse. Again, not the best way to do this. I'll tell you what, I can actually do that.
Sitting down, you can zoom in this way.
Oh, see?
I don't know, the problem is the glare from the light.
Actually,
I think that helped me get the gist, though.
if we can.
Let's go back to the PC now.
Great. Okay. So, can everybody see that now? Sorry about that. This is way better. So this we go. So those would be examples. Right.
Okay, Katie, does
So
that
these
give
are
you
the
enough feedback?
examples of, I don't know if Ms.
Okay,
Gass-
anything additional? Okay, Ms. Davis, did you have a question?
I have a question. Why did you change the entrances down from 2 to 1?
2 weren't necessary for the 199 lots. And Diane could probably add to that, but it wasn't a necessity.
Could you change it back to 2 entrances?
That's not our proposal today, just 1 entrance.
Thank you.
Okay.
If I could add to that,
Sure.
I'm sorry, Ms. Davis, as well. The other issue too is if you add another entrance too, there's an additional impact that you're going to have, for example, on the stream in those areas as well. So there's a number of other issues in addition to just having 2 entrances that come into play that if you have a second entrance, you're going to lose that space for open space purposes, which means you have to reconfigure the entire subdivision in some way because you won't actually meet that 50% threshold because that now will become a paved area as well. So your 50% goes out the window. And again, we're at 50.54% right now. So again, any additions to that in terms of actual paved space will probably put us below that threshold for open space, which means it has to be an entire reconfiguration and new plan altogether. That would be another reason why we wouldn't necessarily just throw in a second space. Or a second entrance, I should say, not space. That's my fault.
Okay, anything else, Ms. Davis? No? Thank you. Mr. Douglas?
Mr. Swansburg, lot 146.
Uh-oh.
Says.
Lot 146?
Yeah, lot 146 says it has an existing building not to be removed. What is that?
Okay, we'll let the developer talk about that. This one down here.
That's the existing house on the property that will remain.
You're going to remove it?
No, it will remain on that lot.
Remain on
Yes.
that lot,
Yeah.
okay. So somebody's already living in it as,
Correct. We own it as part of the property, and it's a rental home currently, but it will remain on the property.
okay. I guess while you're up there, I know that one of the streets says proposed street and it's a turnabout, and I guess it's right near lot 190 or 91. And I believe Mr. Silliman had asked something about the TRC on that. Some type of turnaround or either, not a stub, but either a cul-de-sac or turnaround. To me, it looks like a partial turnaround. I don't know what it is, but it's.
Let's get your name
Yes.
and address, please.
Kathy Linares, 5151 Jefferson Boulevard, 40219. And that is being shown as a turnaround. If it needs to be bigger than that, we can do some kind of temporary easement to allow that until at some point in time, that may be where it would be extended or the road could be extended. So we're just providing that as a possible future connection, but it would be a turnaround at this time.
I was just concerned about the fire department with their vehicles.
Well, that's what I mentioned earlier, that when we reviewed at construction plan level, we've got details for a standard either hammerhead or cul-de-sac, and we would review that to ensure that any vehicles, whether it's garbage, emergency
Buses.
vehicles, can make that turn.
Okay. And then, I guess while the applicants are up there, there was concern about the drainage going into the Lewis's property. I'm looking at the curb and gutter, and I'm looking at the drainage easement. I don't see anything dumping into those properties. Was it before or not now?
Well, I don't think anything's dumping in there. I mean, obviously, it's sheeting that direction. And will there still be some water that sheets that direction? Well, we're committed to not increasing the amount of flow that goes off the property in that direction. And
So-
anything else would be picked up. That'll be something that we dealt with at construction
Right.
and be reviewed.
Right. And you'll be working with the county engineer and the MS4 coordinator on that, correct?
Most definitely.
Yep. All right. Mr. Chairman, I have no further questions.
We'll keep going. No? You have no others? Okay. Anyone else? Anyone else?
Can I ask something?
Please. Mhm.
Okay, I have two questions of the applicant. So the first is Commissioner Douglas asked a question earlier about proposed fire hydrants on there. Now, Keith Smith at the TRC had no comments. Has there been conversations with the fire department on where those locations of proposed hydrants will be?
You know, this has been going on so long. Back in May of 2024, David Mendel was with our office at that time, and I think he may have had those conversations. I personally have not. My view is that obviously we're going to adhere to the requirements of the fire department, and those fire hydrants will be provided. It's just a typical part of the construction plans. So, I mean, we did not show them on this plan. It had never got an additional comment saying I needed to, and I apologize if we should have been showing those, because that would have been a simple thing to just show them every like 400 feet or however they're required, whatever that exact distance is.
Okay. Well, I would suggest just for the commission is that we probably put a binding element in that specifically says that those fire hydrants would be required to be shown on there in consultation with the fire department, even though we do have one that kind of covers all of those in number 3, where it has to comply with all federal, state, and county ordinances. The other question I would have is in regard to the open space, and I'm going to ask this for a specific reason. We don't have too many open space subdivisions in the county, but the ones we do, 10 to 15 years after they're approved, the HOA goes, well, we don't have to maintain those properties. So what I want to get from you is on the record is who will maintain those open spaces in the future once the developer turns that property over.
I see. Good.
The HOA.
Okay. And so I would like to get that in a binding element that includes the maintenance of the property, which everybody in here can have a different definition of maintenance, but that shall include mowing of the grass and removing of any down trees in those areas, because we get a lot of complaints from people in the future that when grass starts to get grown up and trees start to fall, as the HOA goes, well, that's not our responsibility because we're leaving it a natural look. So I just want to spell that out now for 10 years from now that these poor individuals that work with me have to deal with, is that we need to say who is going to be responsible for that maintenance, and that become a binding element in this case.
Yeah, the HOA will be responsible for it. Exact terminology on how it's done, I don't know how you do that, but the HOA will be responsible for it.
Okay, for all maintenance of the open space.
Correct. Now, and there's an argument to be made down in the creek areas that are already natural. You know, we're not planning on mowing those, obviously.
Okay.
So.
All right. Okay. The other thing, can I just make a clarification on something? Senator Titchener came up and asked about a neighborhood meeting. So there was a neighborhood meeting held on this case on May 21st, 2024. Ms. Linares just said this has been going on a while. So, you know, that was held prior to TRC filing. In addition, in part of our TRC process, we are one of the very few counties in the entire state. And trust me, there's a lot of developers that wish we didn't have this, but that has school capacity standards to maintain an environment in all of our schools, whether, you know, ones are over capacity and ones aren't, that maintain strict school capacity. The school board is a part of our TRC process. That's where the binding element comes from, that they're only allowed 31 building permits per year in order to prevent overcrowding of our schools. So I just want that to be known that all of that is part of the process and part of their determination, and that we're only allowing 31 building permits per year. So.
To add to that, for the transportation, I believe Mr. Silliman already addressed that earlier in his presentation. So I think that was an outstanding question too.
Thank you. All right. Commissioners, any further questions? All right. With that, Mr. Swansburg, we'll move into your rebuttal.
Mr. Chairman, as a practical matter, there wasn't a whole lot to, I think, rebut in addition to what's already been discussed. I do want to just emphasize a couple of points if I can. One is, since the picture is already up there, we talked about the fact that there may be some impact on this road and that the Kentucky Transportation Cabinet which is the body that is ultimately going to dictate how this plays out. And we don't have a say in what the Transportation Cabinet ultimately decides. We don't in any way. The Cabinet does. And whatever the Cabinet decides in terms of how this roadway is going to interact is something, again, we're going to adhere to it. We're going to adhere to it. So if the Transportation Cabinet says to do whatever it is in terms of the roadway here from the developer's perspective, of course, we're going to follow that. We don't have a say in the matter. The state has told us that that's what has to happen. So I want to make sure that that is known and that, again, the Transportation Cabinet will have that input at some point, and we will welcome that input when it comes in. So again, want to talk about that neighborhood meeting we already talked about. Runoff, just to confirm with everyone in terms of runoff, of course, just to illustrate the point again, there is a construction phase to this project that is not a phase that this body ultimately is concerned about, but it is one that we will have, the applicant will absolutely have in coordination with the planning and zoning staff to make sure that we are meeting the county's stormwater runoff retention policies and procedures and requirements. So that is in terms of the neighbors who have a concern about that is always a requirement of a subdivision. And that is absolutely one that the applicant will follow again here in this instance. We talk about the sidewalk. Again, there is a sidewalk that is on our plan. It's hard to see. I'll be honest with you. It's hard to see it on there, but it is on there. And that is part of the plan, is to have a sidewalk on the roadway as well. And then obviously, again, in conformance with whatever requirements that the fire department has for us in terms of safety, fire hydrants, et cetera. We've already talked about that. We've talked about a binding element to that effect. There's never been an intention on the part of this development to do anything but follow the requirements of what the fire department says in terms of safety, and that includes fire hydrants, et cetera, around here to address any concerns there might be about that. The applicant is going to follow the law and the regulations of this county in terms of all of these various requirements. That has never been a question for us and will absolutely be a driving force for this applicant moving forward. Did I miss anything? I think that's all I had. I think that's all I had, Mr. Chairman. At this point, again, happy to answer any follow-up questions that we might have.
Thank you, Mr. Swansburg. For any of those who provided opposition testimony, questions, do you have any rebuttal commentary? All right, seeing none. For those opposed, any final comments? Final comments from those who are opposed to this application? Again, seeing none. I'm sorry, you did not provide any testimony earlier. We cannot. Okay. Mr. Swansburg, your final.
Members of the commission, again, I want to thank you all for your time this morning into this afternoon. I want to thank the individuals who came up and gave some criticism, some concerns, some comments about this proposed subdivision. We always know at the end of the day when there's any type of development proposal, including a subdivision, that there is going to be some concern about it. It is an alteration to a piece of property in some way. It does upend the status quo, and so you want to make sure ultimately that whatever you are doing is not going to negatively impact those around you. That's the purpose of why we have standards that are set forth in a subdivision regulation, and that's why we have additional requirements during the construction phase that every applicant, regardless of who it is required to follow to minimize, again, that impact on those around us. Again, respect and appreciate those comments. I just want to go ahead and throw out this slide again, just as a summary of our request. We're asking you ultimately for 3 total things. 2 are going to be variances. The first one is a variance to reduce the minimum side yard setback from 7 feet to 5 feet, or a reduction of only 2 feet. And then a variance to reduce the minimum side yard total setback from 16 feet to 10 feet, or a reduction of 6 feet. And that is contemplated in the comprehensive zoning ordinance and the subdivision regulation as a possibility when you have an open space concept like we are proposing. It allows you to have smaller requirements with regard to setbacks when you are trying to fit it within an overall concept that includes more green space than is generally required for a conventional subdivision proposal. And then as well on this front, again, we would just respectfully ask to give final approval of the preliminary plan that we have talked about today, and remind you all from our perspective, again, the reasons why. One, because it adheres to the admonition of the Oldham Comprehensive Plan related to ensuring complementary and compatible growth with other areas, including neighboring subdivisions. Also limits that impact on the environment that we talked about, whether it's one entrance or two, in addition to the smaller lot sizes. The purpose of this plan is to reduce the impact on that lot here in Oldham County. Ultimately, we're trying to reduce that footprint in the grand sense. And then we're trying to protect the character and social and economic stability. This is going to be a good subdivision if it's approved in terms of the quality and the character that we're talking about, protecting and serving the value of the land throughout the county and minimizing the conflicts among the uses. Again, it's adjacent to an existing subdivision and will tap into the resources and that are in the infrastructure that's already there, as that also dovetails into number 4, which is utilizing those public facilities which are available and which will have sufficient capacity to serve the proposed subdivision upon its completion if approved. So again, we would submit to you, this is a good plan. This is a plan ultimately that doesn't just pave an entire section right now that's an open field. It's one that contemplates a number of different areas and incorporates all the requirements of the subdivision regulations into a plan which we think is aesthetically more pleasing than a conventional plan. And we would respectfully ask that you all grant those variances and ultimately approve the development plan as proposed today. And with that, Mr. Chairman, I yield back whatever time I have, and thank you and the members of the commission for your consideration.
Thank you, Mr. Swansburg. All right, Mr. Fisher.
Oh, okay. Thought she had something to say. So you all have 2 variances before you today, as well as the preliminary subdivision plan. I suggest we do each of these individually. So I'll go ahead and read the variance. The first one, which is for a side yard setback variance. That requirement is 7 feet. They are requesting 5 feet, so the variance on this one is a 2-foot requested variance. Beginning on page 3 in your staff packet, you do have motions to both approve or deny that variance, and includes the potential condition of approval that only applies to the plan presented at the May 27, 2025 Oldham County Planning Commission public hearing.
Thank you, Mr. Fisher. All right, commissioners, everybody clear? Any questions about what we're doing first here? All right. Floor is open for a motion on the variance. Ms. Kraus, is that you?
For docket PZ 25014, I'll make a motion to approve the variance because of the conditions with the open space rules. I think it falls within that. And we want to make sure that any of the conditions, it applies only to the plan presented on May 27th, 2025 at the Oldham County Planning Commission public hearing. And I think that's it.
Thank you, Ms. Kraus. Mr. Baxter?
Ms. Kraus, I'm interpreting what you said to be the design innovations of this case, which are set out in the open space regulations, is what you're relying upon?
Yes, sir.
And you are incorporating the applicable binding elements. I know some of them don't apply to what you're talking about here, but.
Yes, sir.
Yep. Judge, sir, we have a good motion.
Thank you, Mr. Baxter. A motion on the floor. Do I have a second? Mr. Quinn, thank you. Any discussion? Okay, roll call vote.
Commissioner Gwynn? Yes. Commissioner Finney?
Yes.
Commissioner Kraus?
Yes.
Commissioner Jones?
Yes.
Commissioner Marsh?
No.
Commissioner Nasser?
Yes.
Commissioner Hampton?
Yes.
Commissioner Davis? Commissioner Douglas?
Yes.
Commissioner Elder?
Yes.
Thank you. And the motion to approve the single side yard setback has passed on a vote of 9-1. All right, Mr. Fisher.
All right, second variance before you is a total side yard setback variance request. So that total side yard setback has to be a 16-foot minimum. They're requesting a total side yard setback to be 10 feet, and so that requested variance is 6 feet. On page 4 of your staff packet, you do have motions to once again approve or deny the variance, as well as it contains the potential condition of approval that the approval applies only to the plan presented at the May 27th, 2025 Oldham County Planning Commission public hearing.
Thank you, Mr. Fisher. All right, commissioners, questions, motions? Floor is open. Ms. Nasser, is that you?
I'll hit it. I make a motion to approve the total side yard setback variance from 16 feet to 10 feet based on testimony and evidence today that this complies with the design innovations that are set out in open space regulations 5.12 and 5.12A. I also include the binding element as stated by Mr. Fisher.
Thank you, Ms. Nasser. Mr. Baxter?
Adequate motion, Mr. Chairman.
Thank you. We have a motion on the floor. Do I have a second?
Second.
Thank you, Mr. Elder. Discussion? Okay, roll call vote.
Commissioner Davis? Commissioner Kraus?
Yes.
Commissioner Gwynn?
Yes.
Commissioner Marsh?
No.
Commissioner Nasser?
Yes.
Commissioner Jones?
Yes.
Commissioner Finney?
Yes.
Commissioner Douglas?
Yes.
Commissioner Elder?
Yes.
And Commissioner Hampton?
Yes.
Is that everybody?
Thank you. And the motion to approve total side yard setback has been approved on a vote of 9-1. All right, Mr. Fisher.
And the
back
last
to
one
you.
before you is the preliminary subdivision plan. On page 5 of your staff packet, you have motions to both approve and deny that preliminary plan. You've heard evidence and testimony from both the applicant as well as those that have spoken in opposition to this plan. You also have proposed binding elements that have been proposed. The first one being the approval applies only to the plan presented at the May 27th, 2025 Oldham County Planning Commission public hearing. There shall be no subdivision of any lot into a greater number of lots without review by the Oldham County Planning Commission. The preliminary plan must comply with all established federal, state, and county ordinances and requirements at the time of construction plan approval, and this shall include fire hydrant locations that shall be placed in consultation with LaGrange Fire Department and in accordance with Oldham County subdivision regulations that are dealing with fire protection standards prior to construction plan approval. 31 lots per year are allowed per the Oldham County Board of Education. And then the fifth one is the HOA will maintain all open space areas within the subdivision. And then I did not know if we needed to put one in there about KYTC and what may come from their plans. I'll ask Jim Silliman for that, if that we need to make that a binding element based on.
Maybe I'll look to you, Mr. Baxter, on this one. If it's a legal matter, I mean, the applicant said they would definitely abide by that. Do we want to put that as a binding element just to ensure?
Just to ensure it, probably.
Okay, please.
And for the record, the applicant will agree to a binding element that discusses or agrees to adhere to any recommendations by the Kentucky Transportation Cabinet.
Mr. Schwansberg, before you sit down, there was a couple binding elements. There was 4 included proposed conditions of approval, but then we've added a couple today, the fire hydrants and the HOA thing. I assume that your client agrees to those as well?
That would be a correct assumption for the record.
All right, all good, gentlemen? Okay, commissioners, questions? Discussion?
Yes.
There you go, you're pretty good with that. All right, floor is open. Motions, Mr. Finney.
In regards to PZ 25-014, I move to approve the preliminary subdivision plan because it complies with objectives LU 1-1, LU 1-2, managing the development of future development in the county, and LU 2-2, the connectivity between subdivisions and areas of growth in the county. Also, that move that we approve this with the 6 binding elements as outlined by Mr. Fisher.
Mr. Finney, is it your motion, part of your motion, that it complies with the open space subdivision regulations?
That is correct.
If that's part of his motion, you have a good motion, Mr. Chairman.
Thank you, Mr. Baxter. We have a motion on the floor. Do I have a second?
A second.
Ms. Davis, thank you. And discussion. All right, roll call vote once again.
Commissioner Nasser,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Douglas,
Yes.
Commissioner Elder,
Yes.
Commissioner Hampton,
Yes.
Commissioner Marsh,
Yes.
Commissioner Jones,
Yes.
Commissioner Finney,
Yes.
Commissioner Kraus,
Yes.
Commissioner Davis. Commissioner Davis.
Yes.
Thank you. And the motion to approve the preliminary subdivision plan has been approved on a vote of 10-0.
Again.
All right, commissioners, how you holding up? You need a break? Okay. Before we go to break, I need to find out if you're holding up well enough to push through or if we just need a short break. Where are you? We'll go ahead and push through. So we'll take a 10-minute break at this moment and start up with the next item on the docket. Okay? Now, next item on the docket, Mr. Fisher, will you do us the good of serving this one up, please?
All right, so this is docket PZ 25015. So this is the discussion of a proposed ordinance imposing a 150-day moratorium on the acceptance, processing, and approval of applications for the development or expansion of data centers of any size, all private utilities, all private utility buildings, and all data storage facilities within the jurisdictions of Oldham County Fiscal Court as well as the City of LaGrange. So you've got two proposed ordinances that were included in your staff packets. Both of these are pretty much the exact same wording. So I'll go through these individually, but both of the ordinances are imposing a 150-day moratorium on, as I stated, the acceptance, processing, and approval of applications for the development or expansion of data centers, all private utilities, all private utility buildings, and all data storage facilities within those jurisdictions. The moratorium is proposed for a period of 150 days from the effective date of this ordinance. So this ordinance, once again, you'll be approving or recommending approval or denial to Oldham County Fiscal Court as well as the City of LaGrange from your all stance. They will then have to hear that after having two readings. So the purpose of the moratorium in both jurisdictions is to really allow time for staff the ability to create regulations around data centers. It also talks in here to allow us to consider infrastructure and utility capacity, environmental and land use impacts, economic benefits for the community, and best practices and regulatory frameworks from comparable jurisdictions, and subsequently review and update applicable policies, zoning regulations, and standards relating to data center development. A side note, we have had two. Study review committee meetings. We just had our last one last week. We probably need to have at least one more at the end of June before I think the study review committee will be at a place to where we can propose regulations to come before this entire body. That will then have to go before the legislative bodies as well, just like any other zoning text amendment. So, that would go July for you all, and then you could look at August and September for those legislative bodies, although legislative bodies do have the ability to call special meetings. So at the bare minimum, you're talking for LaGrange, for instance, that has one meeting a month, you'd look at the first reading being in August, early August, and the second reading being in September without them calling a special meeting of some sort. Fiscal court could hear that there are two meetings in August if the timetable stays the way it is now of looking at the end of June, coming out of study review, you all hearing it in July, and then going before those legislative bodies. Section 3 in these ordinances are exemptions to those ordinances, and this is the one difference in the two. LaGrange's moratorium shall not apply to applications that have been filed prior to the effective date of the adoption of this ordinance, as well as other incorporated areas within Oldham County or any areas outside the city limits of LaGrange, Kentucky. So that's LaGrange's. Oldham County's exemptions, there are 3 of those. The first 2 are the same, as it does not apply to applications filed prior to the effective date of the adoption of the ordinance. Incorporated areas within Oldham County, as well as the installation, construction, expansion, and maintenance of broadband and telecommunications provider networks already serving Oldham County residents and businesses under agreements with Oldham County Fiscal Court and or with Kentucky State Government. Furthermore, it shall not apply to buildings, huts, terminals, pedestals, or other structures used by broadband and telecommunications providers in the course of serving their Oldham County customers.
All right. Thank you, Mr. Fisher. Mr. Baxter.
Mr. Chairman, just by way of background, the fiscal court considered this issue, and there was some discussion about why they could not just enact an ordinance, or either that or by way of just making a motion, could they enact the moratorium. It was my position, and I conferred with lawyers that we regularly confer with at CAECO about this, that if you're going to make any kind of amendment to the zoning ordinance, and a moratorium is an amendment to the zoning ordinance, that you have to follow the procedure that is set out in Chapter 100 of the Kentucky Revised Statutes. Specifically, Chapter 100, 211 provides that that the legislative body or the fiscal court they can propose a text amendment, but it has to be referred to the Planning Commission before adoption. Planning Commission shall hold at least one public hearing after notice as required by KRS Chapter 424 and make a recommendation as to the text of the amendment and whether the amendment shall be approved or disapproved, and shall state the reasons for its recommendation. So that last part is important in that when a motion is made regarding these proposed text amendments, whoever makes the motion does need to state the reasons that they're making a recommendation to approve or disapprove the moratorium. And at which point, again, this is like any other, for example, a zoning map amendment. You all make a recommendation to the applicable legislative body, and that body will have the two readings and a final vote on adopting this as part of the ordinance. So under the statute as written, it basically contemplates you all having a public hearing. It does not set out parameters for that hearing, and I think it's within the commission's authority to set out parameters for the hearing, committee discussion, et cetera. So, but that's how we end up here with you all having a public hearing to consider the moratorium for both Oldham County and for the city of LaGrange, as you are the joint planning commission for both those the unincorporated part of the county and the incorporated part of LaGrange.
All right, thank you, Mr. Baxter. So if I can confirm, scope is managing the consideration and recommendation of a proposed ordinance for a moratorium.
Correct.
Okay. Commissioners, your input now. It's in your hands. Do you wish to take any public input in this connection? And if so, what I'll ask is that you get a motion on the table with a suggestion of how many minutes you're willing to accommodate in that space. Mr. Hampton?
I make a motion that we do take discussion and it be limited to 10 minutes.
To 10?
10.
Okay. All right. Commissioners, do I have a second? Ms. Davis? Okay, we'll go with a roll call vote. All in favor, please signify. Mr. Elder.
Question, the subject matter will be the moratorium.
Moratorium is the limitation in scope on this, correct? Right? Any further questions? Roll call vote. All in favor, please signify by saying aye. Aye. And opposed, like sign. Motion carries. All right, folks in attendance, there's now a 10-minute window opening for your public comment. Whoever wishes to speak, I want to go ahead and get you sworn in. When you approach the podium, we will collect name and address as you get underway. There's 10 minutes, guys, so use your time wisely.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
All right. Let's get 10 minutes. Who would like to go first?
Good afternoon. My name is Nathan Oberg, 1414 Yeager Lane. I strongly encourage this moratorium. We need to get our house in order. This is a time for Oldham County to really shine on this. It's clear that we don't have appropriate planning and zoning regulations in place, no definitions filed and used. And the moratorium will give you guys and planning and zoning some time to enact responsible zoning regulation for this. I'm going to give the floor here to Randy.
Good afternoon. Randy Strobo, 730 West Main Street, Louisville, Kentucky, 40202. I represent Nana Lambton. I have a few notes that I prepared quickly because I was unaware of really what was going on today, and I'll try to be quick so other people can speak. The first thing, I kind of object to this hearing right now because apparently there's some new text to proposed ordinances that I'm not aware of, and I don't think the public's aware of this new text. So I'd ask you all to postpone this to your next hearing so everyone can consider the new text that's being proposed. Secondly, if there is some kind of exemption that's being proposed to the moratorium, I would really caution you all about exempting uses that can also, exempting quote data centers for certain uses and allowing them for other, or exempting them for some but not for others. And, I don't think, you all are doing a great job. I think your staff is doing a great job right now trying to figure out this issue. Data centers can mean lots of different things depending on their purpose and their size and what they're intended for. They're a unique use that most communities, especially in Kentucky, have not really considered yet, especially communities with planning and zoning. So I think moratorium are very valuable in these kinds of situations. And anything that could be considered a data center, I think should be part of that moratorium, and you shouldn't have different exemptions for different things. I think it's critical really to define what a data center is, and that's what you all are doing with your studies. You all are really trying to figure it out, and I think that's exactly what you should be doing. But in the meantime, because this is such an intense and unique use, you all should spend time studying the issue with a moratorium, and the moratorium will allow you to do that without having these unintended consequences for your community. If your community wants these types of uses, they should know where they want them to be, under what circumstances, and really effectively know how they're impacting everybody else in the community. That's what land use is all about. You all are doing that. So any type of moratorium that you all are considering, I encourage you to include all data centers, whatever that means, and that you all try to figure out what it means and how it's going to impact everybody else. Thank you.
Good afternoon, Commissioners. My name is David Bazanis. I'm the president of Oldham Chamber and Economic Development. I'm a resident of LaGrange. Our office is located at 204 South 1st Avenue. I'm here today, in addition to my role as president of the Chamber, I also serve as staff for the Oldham LaGrange Development Authority, which is the development board responsible for the Oldham Reserve development. OLDA was formed in 2005 through an interlocal agreement between Oldham County Fiscal Court and the City of LaGrange, and was created as a special purpose government entity under KRS 15450, with the express purposes of issuing the bonds that ultimately purchased the Badgett Farm to become the Oldham Reserve project. That board of directors responsible for that development has also entered into contractual agreements with master developers in the private sector, the Hawker Group and Hollenbach Oakley. And I'm here today to request that your recommendations for any moratoriums would exempt Oldham Reserve for fear of potential violation of those agreements. With me today is Jeff Adamson. He is the Oldham Board Attorney, and we're happy to answer any questions related to that.
Thank you. Who would like to go next?
Don Erler, 4005 Old Highway 53, LaGrange. The request for the moratoriums that came from the city and county came to you as unanimous requests of the Planning Commission to consider. They really would like the moratorium. Your planning director, Ryan Fisher, has done a superb job in beginning the process of reviewing the regulations. Data centers are not mentioned anywhere in our regulations right now, and so we need the time to get those regulations in our house in order. We would strongly recommend that you approve and recommend to the governing bodies that these moratoriums go in place to allow your planning staff, as well as all of you, to get a better handle on exactly what data centers are and how they impact our community. Appreciate it very much.
Thank you. Who would like to speak next?
Hi, Barry Laws, 3411 Fendley Mill Road. I just want to encourage time is of the essence with this. We found out that LG&E has 16 projects for data centers. So this isn't a one-off. It's all coming. If we don't have regulations in place quickly, we're going to be in a lot of trouble in the future. Thank you.
And next, please.
I'm Rob Houchins from 1400 Yeager Lane. I am strongly in favor of a moratorium as we do this. What Ryan and his staff are tasked with is to get something in place that doesn't exist in many places. So what they're trying to do is get it right. And so a moratorium would allow us to get it right and get things in place so that we can properly regulate what's coming before us because it's something new.
Liz Englert, 5400 Old Sligo Road, LaGrange, Kentucky, 40031. My question is, and maybe I'm making a mistake here, that when I read the zoning plan for Oldham County, it defines heavy industry as something that creates vibrations outside of the property itself, that produces noise pollution or air pollution or water pollution, and that has lights on 24/7. Now, I'm not quite sure exactly if that definition has changed, has it, Mr. Fisher?
I'm going to answer this, okay?
Okay.
This is beyond the scope of the moratorium discussion that we're having today.
Okay.
We are having discussions in study and review about the content of a regulation. That's what you're asking about.
Well, yeah,
Not
because
the moratorium management, and so you have very limited
When I called the
time.
county, they asked me what my definition of a data center would be. So obviously, there is no definition.
We haven't
We
landed
allowed
on
something
one yet.
without a definition.
Still working on it.
And as far as I understand, it's not included in the moratorium.
This is a matter of how an application might be processed that comes in, but no, it stops it in its tracks until we have developed pieces of regulation that address that specifically. I don't know what else to tell you. We don't have any at the moment.
Yeah, but it does not include the present
We're asking
project.
for an opportunity to get there.
I didn't stand up and be sworn, so could I be sworn, please?
Yeah.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do. John Black, Mayor of LaGrange, 108 North Fifth Street, LaGrange. These fellows here have spoken about the moratorium involving Oldham Reserve. I just want everyone here to know that the city of LaGrange, myself, city council, we're all in support of the 150-day moratorium. There's no question about that. I have no idea how these the older board attorneys are going to play into this issue, but in my opinion, as a mayor, regardless whether a data center goes into Oldham Reserve or it doesn't, but if it goes into City of LaGrange, if it were to ever happen, we want to make sure that there's solid rules and regulations and hopefully work with the older board developers to make sure that anything we'd actually put in the city would be permissible and you know, to the standards that we want to ensure even in Oldham Reserve, such as a business park, but even the surrounding neighborhoods, take all those things in considerations, and hopefully within the 150 days, you all be able to come up with some ideas on how to do that in the event they were ever permissible in the city of LaGrange. So we are in support of the 150 days, but we don't know anything yet about any regulations, setbacks, or height of buildings or anything. So we would wait for that discussion to be had.
Thank you, Mr. Black. All right, commissioners, time for public input has expired. We'll move forward unless you wish to bring forward a motion for additional time. Don't see an appetite for it. Moving on. Okay. So, commissioners, your discussion, your input. Mr. Fisher, there's a question about notice on this that it came up. When were these items posted in public notice?
Well, let me ask staff on if those were in
Mr.
there.
Baxter, is this relevant?
Somebody left their phone up here, by the way. It says father of the rooster or something on the sticker on the back. Anyway, this was posted in the Oldham era along with all of our other contents that's on the agenda.
Fair enough. Okay. So, commissioners, we're at the moment for questions, discussion.
And Mr. Chairman, I would make one point here is that this is a recommendation. So obviously, you all could make a recommendation. I mean, if it was noticed, properly noticed that we were going to consider this, you could make a recommendation that's contrary to what, you could change language in this. So, I mean, this is a draft proposal for LaGrange and for the county that is going to be, again, you all could modify that and make a different recommendation, recommend different terms in it. So I don't think the notice is an issue.
Thank you, Mr. Baxter. So, anyone, Mr. Hampton?
Since there's consensus in favor of the moratorium, I move that we go ahead and have a vote on it.
Is that a motion?
It wasn't, but it can be.
Mr. Baxter, is that an appropriate motion?
Well, Mr. Hampton, let's be a little more specific, if we could, please. So, Mr. Fisher has two documents that we're going to make part of the record if they are acceptable to you. He read to you the comments of Docket PZ 25015 as it relates to the Oldham County moratorium and the LaGrange moratorium and the language contained therein. Are you moving that a recommendation be made to those two individual legislative bodies that they adopt the moratorium verbatim as to what Mr. Fisher provided you?
I am, and I apologize to the chair. I didn't mean to.
That's quite all right.
Then, Mr. Chairman, after I restated it, we have an adequate motion.
We have a motion on the floor, guys. Do I have a second?
I'll second.
Okay. Ms. Kraus, I'm going to run with you. You're the first one I saw. All right. Discussion.
Mr. Baxter, do we need to mention the public hearing at this time with the motion?
It would be nice if you would mention what your findings are, Mr. Hampton, besides just the consensus. That are you indicating there is a need for an ability for planning staff and SRC and this body to be able to formulate appropriate regulations during the 150 days?
That would be great.
I thought that's what you said.
So, you wish to modify your motion to incorporate that language?
I sure do.
And Ms. Kraus, as the second, or you will adopt as well? All right, we're back to motion on the floor. Do we have discussion? Ms. Jones.
I just have a quick question. This says it does not apply to applications that have been filed prior to the effective date of the adoption of an ordinance. And are there any current applications that this will not apply to?
Only the one that you know about. Or if not, everybody in here will tell you about it after this.
I have a question then.
Yeah, please.
On the same lines, that was the question I was going to ask. Okay, what is the motion, or what is the one that we know about? Are we going to discuss that?
Project Lincoln.
Okay.
That's the only one that's been applied for at this.
Okay. Thank you.
All right, further questions?
Mr. Chairman?
Yeah.
I don't know if this is something that needs to be in there or not. Mr. Baxter can maybe, give us his input on this, but I would probably like to see language in there just so it's spelled out a little clearer, is that the ordinance shall take effect immediately upon adoption is already in there, but that the moratorium shall expire when new regulations are approved by all legislative bodies, when the county or something like that? Or is it spelled out that it's 150 days or until regulations, and then it just...
Well, I don't want to have an argument about it. So if you'd like to include that have that included, then you need to talk to Mr. Hampton about that.
Oh, Barry.
What?
So, Mr. Hampton, would you entertain an amendment that says it runs for as long, it continues to run until regulations have been enacted?
Of course.
Okay?
Yes.
And if that means that they've been enacted in, say, 60 days, right?
I don't think that's what this moratorium is. I'm sorry.
Right, so 150 days
Yes.
or enactment of regulation, whichever occurs last?
The reason why I'm asking that is because the reason for the moratorium is for us to get regulations in place. if we get it, regulations in place and enacted by Oldham County Fiscal Court and City of LaGrange, and it's within this 150 days, I would like language in there that says this moratorium expires at that time, not 150 days.
I'm not going to include that.
Okay.
All right, so it's 150
Yes.
days or...
Well, then I can really slow down.
All right, so, all right, Mr. Baxter?
That's
It's
his
a
mo-
recommendation.
And it's his motion.
Okay, all right. So, is everybody clear on the motion? Mr. Finney?
So we're going 150 days regardless, but we're not going any longer than 150 days for sure.
I think we could go longer than 150 days based on that premise, because if we come down to 150 days without a regulation, then we're going to wait for a regulation to be enacted.
But that's not
I'm
what...
not sure that's what we've said. That was my
That's
point.
what we have on the floor.
The motion I'm trying to make is the 150-day motion.
Right. That's yeah. So that means it expires at 150 days whether we got a regulation or not. So that was my point.
150 days from adoption by the legislative body. And I do want to be clear, there's a legal provision that includes, it comes into effect upon publication. That's what the statute says. So, but right now, from now until the county and the city adopt it, this is just a recommendation. So there's no moratorium until it gets adopted by the legislative body. And then there's 150 days from the date of that happens.
Correct. But if there's no regulations established at the end of that 150-day period, what happens?
We come back.
That was my point.
We come back to extend it if that's the case.
In other words, what I'm saying is that the moratorium does not get automatically extended.
That's correct.
Thank you.
All right, so...
Just to follow up, Mr. Baxter.
Yeah.
If the ordinance or the regulations get approved by our legislative bodies, then the moratorium is going to be mute. Is that correct?
Well, if the moratorium is still in effect and it's 150 days, and the legislation did not include language, for example, that said that the moratorium is no longer in effect, and the moratorium remains in effect.
Right. So we'd have to make sure the legislative bodies would have to put something in there.
Would they have to come back here to extend the moratorium?
To extend the moratorium, yes, sir, but the regulations that Ryan is working on also have to come here.
Right.
So there can be a recommendation included about when the moratorium ends in that as well. So, I mean, those are all fluid things at this point.
Yeah.
All right. So does anybody have an idea what motion we've got on the floor right now?
And this only applies to new applications and the processing of those applications
That's
in
correct.
that 150 days.
That's correct. Okay, Ms. Jones?
So this is not effective until the adoption. So if there are any additional applications between today and the adoption of this, then it will also not apply to them.
Those cannot be processed while this is outstanding.
That's incorrect.
What?
You all are making a recommendation.
Yeah.
So until the legislative body, either the
Enacts.
fiscal court or the city of LaGrange enacts it, yes,
Yeah.
applications could be filed.
Right. Right.
Okay. So we could technically get 10 more applications before this is put into effect, and this will not apply to any of those.
It's fair to say. Okay. Mr. Hampton.
Yes, I thought
Right.
that was really easy.
Okay, so where are we with your motion? What did we say?
Still limit the 150 days and include, I've already forgot one thing. Okay.
Well, there was findings that
Yeah,
that-
those
that
two,
you
yes,
made.
including those two things there.
You wanted to adopt both
Yes.
PZ 25-015
Yes.
as it relates to Oldham County and LaGrange's proposed 150-day moratorium. The language is drafted. You wanted to incorporate that into your motion, and you made certain findings about the factual reasons for that to give the staff an opportunity the Study Review Committee and this body to enact appropriate regulations as it relates to data centers.
Amen.
Okay? Good with you. Ms. Kraus, good with you? Okay, further discussion, commissioners? Okay, we're going to go with a roll call vote.
Commissioner Davis?
Yes.
Commissioner Elder?
Yes.
Commissioner Gwynn?
Yes.
Commissioner Hampton? Commissioner Hampton?
Yes.
Commissioner Finney?
Yes.
Commissioner Kraus?
Yes.
Commissioner Douglas?
Yes.
Commissioner Nasser?
Yes.
Commissioner Jones?
Yes.
Commissioner Marsh?
Yes.
Thank you. And recommendation to both fiscal court and the city of LaGrange for the moratorium has been approved on a vote of 10-0. Okay, Mr. Fisher, what else do we have? Oh, hey, commissioners. So I have failed to inform you of this earlier, but I learned during this day that Mr. Fox is no longer part of the commission. He has stepped away. So we give him our thanks for the service that he's given and look forward to the next. So anyway, Mr. Fisher, what else?
So just real quick, I'd like to ask for the board's approval for Commissioner Kraus down there attended a class on May 21st down at CAECO headquarters in Frankfurt on Planning and Zoning 2025 in your county, and it looks like she had an exhilarating day of education. So she is asking for approval of those 8 hours, or 8 hours of training for her attendance at that conference.
So moved.
All right, all in favor, please signify by saying aye.
Aye.
Opposed, like sign. Okay,
That's all I got.
all right, guys. Unless there's anything else, we will stand adjourned.